Ready.
All right. You can actually start off and then I'll.
All right, peace, everyone. Welcome, everyone. This is all right. This is class 3. This is welcome to Moroccan Post. Moroccan Post, law, media, law and history and government class welcomes you. The Moorish, Moorish protection, Moorish treaty protection and consular relations. Moorish treaty protection and consular relations series. This is part 3. This is actually our 4th week of doing this Moorish treaty relations and consular relations, Moorish treaty protection and consular relations series. This is we wanted to put a lot of time into this series. We have to go continue this to the end of the month. So we have two more classes, 2 more weeks until this month is over. Well, next month we'll be going every second and 4th Wednesday of the month. We no longer will be doing weekly. We'll be going second and 4th Wednesday of the month. All right, we'll put a flyer out for that, and we'll continue to make those announcements for the next 2 weeks. All right, so I want to thank you for joining us. All right, so this is we also have these classes are recorded and uploaded an hour after our class is over on the Moroccan Post Media YouTube page. The Moroccan Post Media YouTube page, or on the Moroccan Post YouTube page, Moroccan Post Media YouTube page. We have 12 Moorish body politic formation classes. Those classes were actually live from March 2021 until I believe August of 2021. There's 12 classes, right, on the Moroccan Post Media YouTube page. And we also have other videos that we've done and on other platforms. So definitely, go on there and as I said before, we're about to get started. We have our brother Shem Malachi Bey, myself, and Michael Bey. Will be presenting today's class. Shem will be up with us until 9 o'clock, and Michael and I will take over from there. All right. So hopefully Shem can stay with us without 9:15, 9:30, but whatever time. But we're gonna get it in. All right. So we have Moors and Masonry. We go to moorsandmasonry.org. Moors and Masonry's been out since December 2016. I have Moors and Masonry Part 2 coming your way soon. Moors and Masonry Part 2, the power of Moorish treaties and the recovery of lost Moorish sovereignty, coming your way soon. Moors and Masonry Part 2 coming your way soon. There's other books I have: Etymology and Vocabulary, Supplementary 1, Illuminati, Illumination of the Mind, and How Her Moon and Venus Rule book. All right, so looking forward to putting out Moors and Masonry Part 2. I definitely want to tip my fez and unwrap my turban to Shem Malachi Bey for the wonderful lessons he's have given us for the past 3.5 years. As a result of those lessons, I have revamped the entire book. I've been back on Moors and Masonry Part 2 since December of last year. So almost done, everyone. And Shem Malachi Bey has done great humanitarian work and uplifting fallen humanity and raising all of our consciousness and giving us a higher and proper understanding of this Moorish movement. So I definitely want to thank him for his wonderful work. I have a dedication, I have an acknowledgement in the book that I read about 3 months ago. Shem was not on at the time, but I will not let Shem know what I wrote in the acknowledgement section for him. All right, so thank you, Brother Shem. So we want to get started. All right, so this is a major point, and we want to address is a major point of misconception that I actually had taught for 25 years. And so we want to spend some time on this. We're going to read back 4 weeks ago. Shem made some comments relative to, I'm going about to read them. Bring them up, Terrence, or Samantha, Amanda, would you want to read? Bring that paragraph up, Sharon, Terrence.
Amanda can't read. She can't read this
Yeah,
time.
somebody else could read, please, because I'm driving right now. Sorry.
Oh, no problem. I can read. I just can't see it. I can't see it. It's still too small. That paragraph that reads United States Federal Courts. Right there. Just bring that up, Terrence. United States Federal Courts. Bring all the way up.
The United States federal judges, you mean, bro?
United States federal judges. See, yes.
Or the United States federal judges and states judges of the various states in the Union of the United States are only looking at the native Moors' political status as a citizen of the United States and residents of one of the states in the Union of the United States. The United States federal judges and the various state judges of the states in the Union of the United States know that only a citizen of the United States and residents of one of the states in the Union of the United States can ask the judge to speak on a matter in a United States federal court or the state's courts of the Union of the United States, unless in treaty cases that do not have a capituary or extraterritorial consular jurisdiction clause, such as Hornstein versus Lenham, Ware versus Hilton, Society versus New Haven, etc.
Is that right serious?
Yes, it is, brother. Yes, it is.
Oh my goodness. I saw your name and I said, that's my serious voice. Oh my goodness, brother. I want to tip my fez to you, brother, and unwrap my turban to you, brother. Was out here with us for, we met in 2010, and he relocated to Phoenix, Arizona. All right, so it's been a while, brother. Thank you.
Definitely.
Thank you.
I appreciate you always.
I'm glad you saw the, I'm glad you saw the link, and I'm glad you joined us today, brother. Thank you. All right. So let's get into this. This is a misconception. I've been taught, had been taught that, going into United States courts, and that, and this whole concept of that, yes, we are Moors. We are Moors. That's your consanguinity. There's no process in the world. No, there's no paperwork, no Moorish government, no Moorish body politic, no Moorish process can make you a Moor. That's your consanguinity. All right. So we're looking at nationality, and tied to that is, and based in this consanguinity, national origin, pedigree, descent, ancestry, lineage, genealogy. So the issue here is political status. So we are Moors. Now, the issue here now where we're addressing is conscious Moors. Conscious Moors, because only with conscious Moors would do this, as far as that they know that they're Moors, and that they will go to a traffic court, or a state court, state traffic court, or they will go to a United States District Court to address a matter. And we were not taught that by doing that, we will be, by that expression, acting as though we are United States citizens. That had never been conveyed until Shem Malachi Bey brought that to light. That never, Shem is the only one that has conveyed that with clarity. So I wanted to put, though we addressed this, I wanted to put more time into this because this was a statement that Shem had made, I think 3-4 weeks ago, in answering the 11 questions, treaty questions. And I relooked and I watched the video of that class, and I actually took down these notes, and I actually made some, as far as made some detail, add some detail to it. So this is the Shem Malachi Bey's comments. And so we want to Shem to talk, to elaborate on it. And actually, Shem, but before Shem does that, I want to read the next paragraph. So we want Shem to elaborate, and we want to open up for comments, criticism, and discussion. So let's read, of our series, we're going to read the next paragraph.
Got you, brother.
Did you want him to read the one that we underlined? Or is it the next paragraph under this one that you're talking about?
Yeah, with that what happens? Yeah,
Got
what
you.
happens? Yeah, go ahead. That next one. What happens?
Got you. Put it on the screen. I'm looking at you, bro. Got it. Okay. All right. So what happens when either the United States federal judge or a state judge adjudicates a case involving a Moor? How do Moors expatriate themselves out of Morocco? When either a United States federal judge or a state judge hears a case involving a Moor, this constitutes a change in the Moor's political status because the case is being heard by a foreign judicial officer who is an officer not authorized by the treaty. That is, a United States federal judge or state judge of one of the states in the Union is not authorized by the treaties between the Moroccan Empire and the United States to hear cases involves a Moor. Only the Moorish consul is authorized by the treaties.
All right, this is a major concept, and we'll revisit this about 100 times. We'll revisit this about 100 times or maybe 1,000 times in the next 2 or 3 years, and without exaggeration, because this is a major concept because of the misconception, because of the 100 plus year of misconceptions that's been out there. Like I said, this was rooted in me for 25 years, the misconception. So I know it's going to take time. This is why we're revisiting it. We're going to take time on this. We're going to slow walk this. This is a major, major, major point. We get this, we're on our way. We get this by the tens of thousands, we're on our way. This is a major, 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 major point. All right, Shem, you want to elaborate?
Is this part of that Consular book, brother?
See, what's going on is that the United States in the 18th century, after Lincoln got assassinated, passed the Expatriation Act. And what that did, that allowed anyone to change their political status. See, they in the Immigration Act, they got a National Immigration Act, they got a loss of nationality. It's not loss of nationality, it's expatriation, change of political status. They won't tell you this because they run the fraud. Fraud is being run. So they figured that 1 in a million won't figure this out. Not a million people will figure this out. What's going on is that when a Moor going to the court and petition the court, the only way to get jurisdiction to the federal court or any state court is through a statute, a legislative act of that state, creating that court, giving that court power to speak, or tribunal power to operate in the territory of that state. And what happens is when the Moor goes in there, he got to quote that statute, the federal or state statute, to get a court jurisdiction to hear. When that happens, he changes political status, meaning that the only one that normally does that is a citizen, a resident of the state, and a citizen of the United States will go to that government for protection. And this is what I mean. If you go to the government for protection, they may make decisions. You call the police, the fire department, or they give you housing or food stamps or give you food vouchers. That you depend on the government. You suck on the government breast, your mother breast. The government becomes your mother and your father. Now you become a ward of the state because you come under what you call the Refugee Act. You in a land that's not your country. You can't take care of yourself. So we got to remember that. It's very important to understand that in order to go in these courts, the courts got to have jurisdiction over the thing, the reed, what is your vessel, your body, your vessel. So it's like a ship. When a ship pulls into a certain port, if that ship is from a foreign country, a foreign state, once it pulls to that foreign port and have a problem, it got to go to that foreign port court because they all registered with the United States as United States citizens. And that vessel is in the United States territory because the United States, the federal government signed a contract with the Crown, the 1783 contract to go back into the colonies as individual communities, but they agreed to pass the Constitution, was the creature of the law, was the father and mother that create the creature, was the United States. So the United States is the central government that signed the treaties. Therefore, anything the United States endorsed or signed by the president and ratified by Congress becomes domestic law in that state because that's the head body, national government. So when a Moor goes to court to get relief, he's expatriating himself because no longer receive the protection of his country to a treaty, an international agreement. He's going to a court, asking them to take care of him and give him aid, give him a security, protection, or remedy. So therefore, he expatriating himself out of the protection of his country. He means changing his political status. Because if he holds his status together, the Moorish government set up with councils. And the council is the only one that can hear a matter based on international agreements. So once the council becomes a judicial officer, let me tell you what, the United States already, to the State Department, already ordained a central organization to hear all international disputes, the conventions, foreign treaties, declarations. That institution is the only one can hear that agreement, hear the dispute in violation of the United States, in violation of a treaty or a state. That wasn't delegated to the federal court. And the treaty that was delegated to a central authority in the Justice Department. What happened is you gotta have a government up so your counselor can give a counselor notification of counselor jurisdiction and do a letter of interrogatory and hear that matter. Nobody else in the world, nobody else got jurisdiction with that organization, the State Department, and that Department of International Affairs of the State Department. Nobody else delegated that authority to Congress and the president, but that central authority. And what happened is when Moore going to the federal courts, he actually doing it. They're doing it because one, they don't know, and one, because they've been under misconceptions for so long and haven't learned how international law is governed in the United States. And with international government, foreign states and nations. So it's two ways that a Moor, if a Moor don't have to come into the Nationalization Act because this is land, but you can expatriate yourself out of the protection of your land by what? Going to a foreign government and asking them to give you a remedy. When in fact, the remedy's in your treaty. That's the remedy, international law. That becomes domestic law for you. Let me explain what I mean. The Indians have not been taught this. On the case of the Hague, when the United States and Great Britain went to the Hague in New York, it came out that Indians was called British nationals. I'm gonna hear this. I want you to hear this. They're British nationals. That means when the Indians got the United States, they don't supposed to be going to this court. They're supposed to be going to the calling for the council because it already been decided internationally they British nationals. So when you're not taught this and they indoctrinated, they take the attorney, that's why all of them get an attorney. Attorney's not going to tell them this because attorney have not been groomed in school, school in law and jurisprudence about international law. So I'm gonna correct something last week came up. They don't obey the decision of the criminal court of CJ, the Hague Court. They obeyed them. You have to do 28 USC 7282. Any decision coming from an international organization, the UN, the United States have to take that decision and go by the decision. The United States Supreme Court got to go by the decision in state courts. Why? Because under 28 U.S.C. 1782, any international organization make a decision. The United States are bound by that. So I'm gonna correct that from last week. They do have to go by that. It's already written in federal law. Now, let's get back to expatriation. A Moor is not school in school system, is on schools. He don't know this because he wasn't educated in this. He wasn't given a seminar or rights, or his rights, protect his rights. Now,
Or were they educated by conscious Moors? They were neither educated by conscious Moors. So that's not just,
Yeah.
we don't want to just throw it on the Europeans.
I think you have to
They
do
were
thank
not,
you.
they were
I
not,
thank you.
because I remember 25 years for me, remember 25 years of misconception.
Yes.
All right.
Yes, I'm doing it right. There was nobody, no Moors leader or anybody taught the Moors true jurisprudence or international law and its status. And it's being taught now.
Except Shem Malachi Bay. Except Shem Malachi Bay.
Yes. A Moor, as the stat, everybody go to the United States and type in the expatriated of Congress. They come up and read it. The reason why they did that because you can expatriate yourself. That's your right. I'm gonna be honest. I'm not anybody's a conscious Moor, not an unconscious Moor. A conscious Moor have a right to expatriate itself by what? By performance, by a contract, express contract. By what? Not going to his council, even though that's what government structure is very important. You got to have government structure, you come together and form government structure, so that way we can come in as indigenous native Moors under UN and ratify UN charter. Therefore, you become a nation in your own land without being protected by any other foreign nation. The moment that nation protect you, and it start with your mother. The mothers are unconscious. Sorry to say, but our mothers are unconscious. That's where it started. Start with the mother. The child get into all kind of adhesion contracts to his mother because he's his mother goods. And what she do, she go to a foreign vessel, which is a hospital, that's docked on the shores of the United States territory in the jurisdiction of the state. She go there, drop goods, and put what you call a registration certificate, which goes under trust. Under colony was already set up as a British trust. The United States went back into the trust territory and formed a corporation, a corporate community. They still under that trust law. So what they do is register you go automatically under trust as a subject, as property of the state and a subject of the crown. And what happened is they use you as a surety and collateral, as a guarantor to pay their debts. They owe the crown. By what? By taking away your nationality, stripping your nationality to misguidance and miseducation, indoctrination, and apartheid, genocide, cultural genocide. Now they become the guardian, a conservative over the Moorish state, over your state, your body. And it happens all start with the mother. It all start there. So expatriation is your mother expatriate herself too. The moment she go into that vessel and have a baby, she get a child a name, she sign a registration form, which is a certificate, that was a certificate of live birth. Certificates are holding trust. What trust? Not just the state trust, because there's no title in state. Let me break this down so we get the perfect understanding. When the court say there's no title in state, you know what that means? That the titles in the colonies, know why? Because the kings and crowns were the first ones signed treaties, successor treaties, drawing off longitude and latitude of the boundaries of the company. The United States went back into the territory, so they never had title. They went back and land is already titled to the crown. All they did was operate a corporation, corporate state in that territory. That's why they bound by the treaty, the J Treaty, and the Investment Treaty of 1783, the Peace Treaty of Great Britain. Now, what we have to understand is that our status, we have to come together and form government structures so we can take status. So we also can legislate acts, bills, and statutes to protect ourselves, protect the matriarch principle of the woman. Like look at the United States, they passed the acts to protect the woman, labor acts. We got to do the same thing, pass legislation to protect our women, our matriarch, so the kids cannot be taken from the woman. They can't usher in there and say you don't have a political status and take your child. So what we have to do, expatriation is when a people or a national or foreign government going to another government and say he want protection and ignore the laws that did protect him. Grievance that protect him. Therefore, he's changed his political status. In order to go in that court to him talk, he had to be considered as a citizen or what you call a citizen or resident of the state, a United States citizen.
A citizen, through naturalization, all right, natural born citizen.
Yes, yes, sir. And how they do it is that when he go to court and they go into court, the court got to have power to speak. He get the court the power when he quote the statutes. That means he's claiming to be protected under these statutes. Now, a Moor that's a knowledge board that's operating a national government, Moorish government. The moment that he has a problem, he goes directly to his council. The council invoked the council jurisdictional notice. There's a dispute, criminal or civil, between a Moor and the United States. Just like the courts, the federal courts, the circuit courts were created by a legislative act of the government. The government already created an agency. All the agencies do is hear international disputes on letter interrogatory. That's all they do with councils. They supersede the federal court because the federal courts can hear international law in that court. Only when one is considered captured as a ward or a citizen of the United States, like an Indian. The reason why Indians go in, I'm gonna explain something. When you see a national go to the federal courts with letter interrogatory, 9 or 10, it's not him. He makes an argument, but they call it counseling. Once you say I have the proper right to counsel, now let me explain what that means. It's the case on that right now. Well, 2 cases in Germany and Mexico were consolidated dealing with the right to counsel. And what happened is the Supreme Court say is the individual right, but the treaty is self-explanatory. It's treaty self-executing because it explains that yes, the international law does have a right. Now the law enforcement got an obligation to inform the national that's arrested and detained like they form under Miranda warnings. You got to write the calendar, and then held against the court of law. Once the law enforcement realize that this is a foreign national, he had given the consular rights on consular relationship. And when that's not done, now let's still have. When that's not done, the counselor now on a letter of interrogatory will go to international organization and do a writ of assistance and have the Supreme Court grant the relief they need. This is a violation. This is very important. Any questions?
Yeah, before you go on, if I'm serious, you get a chance, text me. You have my number? Text me. Put my number in the chat, man. Somebody.
I'll put mine in there too.
Yeah, put it in there. So yes, your name and number. So all right, because I don't want you to get off before I have your number. All right, so this is very important, very, very important. We want to spend. We're not going to rush through this. We're not going to rush. We're going to take our time. Mike, if you want to chime in. Council Mike, this is very important. This is a major, 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 major concept, that we may have to revisit next week, the week after that, because of the misconceptions. Thank you, Amanda. Because of the misconceptions.
Any questions?
Yeah.
Any questions, please? Any questions?
Yeah, Darian here.
Yes.
Peace. So okay, I seen this structure in the Moroccan general treaty between Morocco and Great Britain, where the consular is set up to hear matters on their nationals, and the Moors here, we have a consulate that hears matters over us. I seen that structure in the treaty. Now and I understand. I'm just reason I'm clarifying. I'm just trying to see if I'm understanding you. The same way they read Miranda rights to United States citizens is the same. They supposed to also inform nationals that they have the right to their council. That's set up.
Absolutely.
Okay.
Yes. And he put the contact, not only read it, he put the contact the council.
Okay. So how would they know that one is a national? I think I read somewhere where they assume
Good question.
they assume that we're automatically United States citizens.
Let me explain something going on. See, what happened is, for a long time, everybody been misguiding the people to false concepts, misconcepts, and constructive speaking, misleading speeches. Let me explain what I mean. First of all, our ID card is identity card. The identity card is already set up with a website, a verified address, and they ask you, I'm a foreign national, I'm a governor, a foreign governor, world's governor. Listen to me. They know they can contact the State Department. They would tell them, you got to contact, give notice, you got to get consular notification. What I mean is that the government, before you even go out there and start using it, they send a proclamation over to the agency the agency that handle all international affairs in the State Department. They hand to Homeland Security. The proclamation goes to all law enforcement, government, state police. So they got the proclamation. They know that it's a national that's going to be traveling with the IDs. It's called due process of law. What happened is the council give notice that any national can stop to the for the organization that handle all international affairs to notify this office right here. Once that go out to all law enforcement, they're without excuse now. So if a national get detained, a national can open his mouth and say, excuse me, I got a right to call my counsel. They got to give you a phone call. See, phone call got to be given to you. When you call your national, the national will come down and stop everything. No more process or nothing, because the jurisdiction of the national is with the Justice Department, with the State Department, to international affairs, not to this court, not to this magistrate court. You have jurisdiction. Now, once they find here national, the judge can't do nothing else but step back and say, it's out of my hand. I don't have jurisdiction. If tell a DA or whoever it is, you got to go through the organization. You got to deal with the counselor. That means the counselor will do a letter of regulatory now and say, okay, I can have released under my custody. He got the law here. By law, they can do that. The counsel, I released on my custody where he can be held, and therefore you got any witness or any evidence, you can bring it to the agency where I can hear it. I'm the only one that rule in that matter. That's called consular protection. See, this is never taught.
Let me say this, Shem. Let me say this. So let's go to the misconceptions. Let's go to the misconceptions. Let's go to what they know, because they know misconceptions. All right, the misconceptions is that a Moor is given a proclamation. Moor is given a proclamation, and they send proclamation to, the United States Department of Justice. They mail it. They mail this proclamation. What you're saying, Shem, is that the proclamation comes from a head of state, a Moorish official. A Moorish official does not give, an elected Moorish official does not give a proclamation to a non-elected Moorish Moor. Moorish official, it comes from a Moorish government office. From a Moorish government office, Moorish official sends it to the United States. So a Moorish official does not give it to a Moor to do that.
No, that's right. No, don't give it to
This is what they know. I'm telling you, Shem.
Okay, got you.
Out there for a long time, and we gotta look at you. You're doing a wonderful job. So my job tonight is to bring the misconceptions. You talk, then I bring the misconceptions. This is the misconceptions. This is what they know. We have to always. This is the misconceptions. So my job tonight is I'm the misconception guy. I'm going to bring up the misconceptions, all right? because that's what they know. They don't know what you're teaching. They know the misconceptions. You're doing a wonderful job.
Will you ever see the United States take a citizen or a voter and give a proclamation to them and say, go and take it to France or a foreign government so they can acknowledge your treaties rights? They don't do that. They do government relationship or government relationship. Any other questions?
Okay, I got you. So government relations, the Moorish government notifies the United States government that so is a national of that government, and if I was to break any other stipulation within the treaty and be captured by the United States, of one of their officials, automatically they will know that I'm a national because of that notification that was given by the Moorish government.
Yes, because now that, see, if they got it and try to ignore it, the moment, let me tell you what happens. See, once the moment they deny that, ignore that, you assert your claim in the state court. When you go in the courts, excuse me, I don't have a right to counsel, I have a right to my counsel, not counselor, counsel. So I haven't got my counsel. Nobody haven't given my right to counsel. They got to give you a phone call. And a lot of times, some people call their family and say, notify the Moorish counsel, let them know I'm arrested. Now, Michael speak on this. Michael, they're hand in hand with the courts dealing with. Explain it to him, Michael. Break it down with him, Michael. Michael.
Yes. Peace. Yeah. Say it
Break
again.
it down, Mike.
What did you want me to break down?
When a national of your government had a ticket problem, you went down there on the council notification jurisdiction, and tell them how you dealt with it, how they dealt with it.
Yeah, we did a petition notice removal based on diversity of citizenship pursuant to federal statute.
No, I thought the ticket,
attached with a letter. Sorry.
The ticket, when you went down to the DA and that dealing with that ticket, and how they dismissed it based on a national.
Okay. Okay, because it was a few different experiences. That one in particular, I was fortunate enough to not have to go, to New Jersey, so the New Jersey political zone, and it was a ticket pending issue, and I was able to just go in there and assert that I was counsel on behalf of the defendant. And I just told them that, they was protected under treaty. They was, they was a foreign national. And the prosecutor had asked me, are you saying to me that that the defendant is not able to be issued these tickets? I told her, yeah. I said, precisely. And she said, okay, so we're just going to move this matter for dismissal. So she asked me to, just wait for the judge to call on behalf of the defendant's name. And the case got dismissed. But it was really, it was that simple.
Now, let me explain something. That's not an individual situation. That's a Moor using Moor's treaty to feed the case. That's how the Moors benefit. Now, even though Michael went down there, but Michael superseded state authority because he by going down there, he invoked the council jurisdiction, the council court. So that's very important. Individual Moors, that's why you do a lot of individual Moors go down and fight tickets. A lot of them want to 10 years. A lot of them want to jail doing time 5 years or get charged resisting the arrest, tamper with this and that. Talking about the judge's oath. You don't have to for the judge's oath, a judge over office. He don't represent the Moors government. He's not elected. He has a delegation authority by the Moors government to hear any man.
That's what I'm saying. That's another. I'm glad you mentioned that, Shem. Let me slow you down. All right, so Shem did my job. Shem threw out a misconception. All right, one of the misconceptions that's been out there for over 30 years. All right, is this is what they know, is to ask for the judge's oath of office, or get the judges to research the judge's oath of office. That's an instruction. That's been instructed for over 30 years. This is what they know. So I'm glad you mentioned that. I just wanted to slow slow that down, all right, and get us, because I don't want you to go too fast.
Okay.
I want to slow down every misconception, and clearly articulate why it's a misconception. Why it's a misconception for Moors to research a judge's oath of office and put that as they're preparing for their case. As they're preparing for their case, Moors have been taught to research the judge's oath of office. All right. Why is that a misconception?
Hey, Abdullah.
Yes.
This Darian. Okay.
No, hold on, Darren. No, Darren. No. Hold on, Darren. Hold on, brother. I want Shem to address why is it a misconception for Moors? Moors have been taught by conscious Moors. Conscious Moors have been taught by conscious Moors for over 30 years. I bear witness. Over 30 years. As preparing for their defense to research the judge's oath of office. Shem mentioned it's a misconception. We want Shem, if we're just going to stay on here to slow, we got time, we're going to slow this down. We got next week, got a week after next. We're going to slow this down. Why, Shem, is that a misconception?
Because, first of all, the judge's oath of office only take an oath to obey the Constitution. So therefore, you don't have to put his oath of office on a record because he don't have jurisdiction. If he got an oath or not, he don't have jurisdiction. That's the only plain thing. He does not have the jurisdiction to hear something that the United States agreement that the United States entered into and is self-executed, how the matter should be heard. Who's the kind of officer, official that can hear it? That's the end of it. You don't have to do that. Another thing go with that, it says, they move too fast. The oath of office also, they talk about, well, I'm accredited. Now, Ms. Spencer, you're not accredited because first of all, your mother put you in a birth certificate. You're a debtor, a ward of the state, you're a debtor. And the Moors governor is the creditor. The Moors government takes you become a creditor the moment you come back in your proper status, your proper standing, be a proper person as a Moor. That's what makes you a creditor because the United States is the debtor to Morocco under the treaty. And the treaty of the British government, they're debtor to the British government, and the British government make it clear that if a Moor is traveling in her dominion or her rim, the protection of the British Constitution, in other words, whatever British law protects British national citizens, it protects you in the colony territory. The United States is there. So you can stop in a state that's a colony, a British colony. Then you got self-executing right to run their own government. So you don't need a judge over office. What you need is a council to help you out. Because when you have the judge over office, what you're doing is saying that you got to show your over office you agree to obey the Constitution. You're not there about obeying the Constitution. You're saying, I'm here because I want my council to represent me. That's all it comes down to. You start doing debtor and creditor, they got you already because you're a debtor. You're a debtor on a birth certificate your mom signed. And the only way to get yourself out of the expatriated state is you got to come with the Moors government, a population of people, voters. A political, international law gives the description, Abdullah, say it again, on international law, how you consider indigenous Moors government. Say that, Abdullah.
All right. I want to still stay on this oath of, all right. So, because Moors have been taught, conscious Moors have been taught by conscious Moors that, the only way that someone claiming to be a judge to have jurisdiction is that they have to have an oath of office, and that they even been conscious Moors have been taught by conscious Moors that to draft a writ of quo wanto, all right, and in the writ of quo wanto, all right, and preparing for this defense is to have their oath of office, or if lack thereof, to show that the judge doesn't have an oath of office, and as a result, the judge does not have authority. All right. Moors have been constructed on this by conscious Moors. So I just wanted to slow this misconception down and I want to analyze that. Is any questions, comments on this part of misconception? This is major. We're going to slow this down.
Any questions?
No
So
question.
what was the purpose? What was the whole purpose of even asking for the oath of office? You know, because you're correct. If he doesn't have jurisdiction in the first place, what purpose would the oath
No.
even serve?
All right, that for all right, for United States citizen, that's
Right.
for a United States citizen. Let's put it that the purpose it was served for United States citizen. I'm all right.
Okay.
I'm a United States citizen, so I'm a United States citizen. The
Okay.
purpose it would serve for me, if as a United States citizen, would be all right. That as an oath of office is that the only way that natural person could sit on the bench is that they would have and have authority. They would have an oath of office. That is only for United States citizens concerned. United States citizen.
That's
Not
true. In federal statutes, that a judge is sitting behind the bench, have an oath of office,
yes.
affidavit of employment. There is federal statutes that a citizen of the United States, the resident of the state can say, well, you violated the law. You can't hear this case based on you not fulfilling the obligation of federal law. And that's true. So right, Abdullah, right. There is statutes and codes that gives a citizen of the United States and a resident of that state power to ask the judge to put in the record that the judge don't have this, so that way something go down, the judge will become de facto, not de jure, because he's illegitimate and illegal. And the United States Supreme Court made a case of de jure and
United
de
States
facto.
citizen.
That's
That's
right.
the key.
For
United States citizen.
that's de jure, but for a Moor, that's de facto. It's illegitimate and it had a legal effect because the judge don't have the power to hear Moore's case anyway.
If the judge has an oath of office, so let's go that way. Now let's go that way. The judge has an oath of office. The judge that is still for more. That's if that matter is whether the judge has an oath of office or not. It's irrelevant for a Moor, not for United States citizen. It's vital for United States citizen. For United States citizen, that's a major point for United States citizen. But for a Moor to concern, for Moor to raise that issue, for Moor to do the research, for the Moor to be concerned about that.
It's vain.
For United States citizen, I just want to spend the time on this. It's major. For United States citizen, yes, but not for a Moor.
Absolutely.
A Moor would be what? The Moor a consul, because only the treaty delegates only a consul authority to hear disputes and matters regarding a Moor as a defendant, right? So the only issue for a Moor would be the Moor's consul. This is why we gotta slow. This is why we're slowing this down, y'all. We're slowing this down.
Yep.
All right.
Absolutely.
Yeah,
Any questions?
Appreciate that.
Yes.
Yeah, that's very
That's
clear.
a question, my Lord. That's a question, my Moore's brother.
We just stay on this, man. Let's stay on this because you say, you notice when I slow this down, that's why we don't want to rush by this. And as I said to Terrence, we want to revisit this. This is a major point. Like if it spills onto next week, so be it. This is a major point.
Yes, the judge over office does not.
I know all the misconceptions. I know all the misconceptions.
I agree with Abdullah. A citizen of that state and a resident of the state and citizen of the United States can bring their argument up, because in order for a judge to hear any matters as a judicial officer of the state, he got to have that criteria. He got to fill that criteria, procedural criteria.
Absolutely.
But a Moor
Absolutely.
is a non-citizen, non-immigrant status, an alien. On the alienation, a Moor is not bound by the laws of the United States. Therefore, look at the judge over office does not do anything for a Moor. Making that clear, because the judge don't have power anyway to hear. So whether he got an over office or not, he still don't have power. Why you don't have power to hear it? Because he got an oath to say he got to obey the Constitution of the United States. Now, I want you to hear this. When he said obey the Constitution of the United States, that means he got to take heed to Article 6, the Supremacy Clause. So he know if he hears the Supremacy Clause, he can't hear it. Treaty the law of the land. Our Congress got to do it. So the more all the Moors doing is perpetuating itself. He don't want to do that.
My man. I'm a man, brother.
Any more
All right,
questions?
so, any other questions before we concerning this matter? Mike, you have any comments on this?
No, the only thing I just wanted to just to elaborate further for clarity, give people, a reference point as we always do, so that it don't seem like we talking and just, once, and having no type of reference for the people. The Dred Scott case, Dred Scott versus Sanford, 1857 case. It reads, let me just give people the quote so people get like just a brief synopsis of what this case was really talking about. It says that the United States Supreme Court decision in which the court ruled that African Americans, now before I continue, African American is a misnomer, just know that African and African American, those they was used interchangeably to refer to Moors. So the Supreme Court decision in which the court ruled that African Americans, whether enslaved or free, were not citizens of the United States and therefore did not have the right to sue in federal court. The court also ruled that the federal government could not prohibit slavery in the territories. The decision was a prime factor leading to the Civil War, but was eventually rendered moot by the 14th Amendment to the United States Constitution. So just to give us some insight and clarity to what was just expressed.
Thank you, Mike.
It was already declared. Yes, it was. You're welcome, Lord. It was already declared in a pretty contemporary case. Like I said, 1857. That was less than 200 years ago. This case declares that people of the African American people of quote unquote African descent, which are Moors, cannot be citizens of the United States. And that case was never amended. So this is why when we're in courts and we're in court procedure, and I've been guilty of it myself and, my circle who I came up with, under that study dean. We used to do that often. We used to ask judges for their bond, give us your oath of office and stuff. And, quite frankly, in my experiences, they laughed at me. Literally, they would snicker and laugh, like, what is this guy talking about? But obviously now to shed more light and to really, really come to, the really fulfillment of what it is that I was doing, saying as opposed to what I was supposed to be doing. This is the right method and this is the right procedure. And these are the reasons why. So the Dred Scott case is a good reference point for anyone that has misconceptions that's in this study group. Moving forward, you have a case reference to just remind you of why you can't do that. The Dred Scott case was already declared in the Supreme Court, highest court under the United States jurisdiction. It was already declared that Moors cannot be United States citizens. So being that was never amended by an act of Congress, it can be challenged when you're being that's a very paramount case that you can use to challenge the jurisdictional authority when you're inside these federal and state courts. I can't be in here pursuant to Dred Scott case versus Sanford. You can't be there.
Another case, if ever go to read, is the Amistad case. Now, this is where Michael brought this up. The 14th Amendment expatriated the status of Moors and indigenous people. See, the 14th Amendment, the United States government, Congress, filed amendments to expatriate the people, the natives. by claiming they're 14-member citizens. They go to the court and receive protection under the Constitution. That's a form of expatriation of political status. Now, a good case to read is the Amistad case. I'll bring a very important. Thank you, Mike. I like that. Mike just brought this to my mind. The Amistad case. They went for Africa. They were taken by a European powers from their tribe, the king and his subjects. Put on a ship that by laws of nature, human rights. They had a right to defend themselves and take over the ship, to steer the ship back to their country, because that was an act of piracy on law, on high seas. So what happened was the ship crashed. They didn't know how to get the ship back home. It crashed on one of the states in the United States territory. When that case went to court, how they won the case was all the way through the court, they claimed their status. They never claimed to be under United States protection, a United States citizen. They always checked that they came from a sovereign nation, even though it was in Africa, and that they had a right to protect themselves. That's a very good case. Everybody should read that. The Amistad case, read that. It's a very good case.
Sundry free Moors, right? Sundry free Moors.
No. That's the Sundry free Moors is different. The Sundry free Moors was taken in servitude by the African kings off the ships. See, I would say right now, a lot of people don't know Africans. The people in Africa was coming over here in Morocco, taking the Moors, the women, and the men, and selling to Europeans on ships. Yes, that was going on. They took some Moors officers, officials, took them in servitude and took them and then promised their liberty, put them on a British, United States ship, and put them on there and say they foreign nationals. And when they got to the state or the colony, they took and sold in servitude. And what they did was they took and got their freedom, declared their freedom under that English name. And what they did was, so they had a mistake. They go to the courts. They went to the parliament, the state parliament, the legislature, and said, look, we are nationals of a foreign government taken by a foreign prince, an emperor. And there's a treaty with the United States, and that we're not to be judged on the Negro Act. In other words, we're not Negroes. They're making a claim. We're not Negroes descent out of Africa. That's the Negro codes apply to. Anybody that claim to be of Africa, or more out of Africa descent, they claim you to be a Negro. I mean, already the connotated instruction, vices already created. So they claim to be Moors. By doing that, the House did an inquiry, and the House had to pass the Moorish Sundry Act, stated that in this state territory, based on what? International law, the state went by international law. Then the laws of South Carolina does not apply to them. They exempt. That's called the Free Moorish Sundry Act. Now, this is very important. These men are not even public officials, but the fact of the matter is they stood on treaty. They stood on a treaty. They didn't go to the courts to enforce their rights, because they went to the courts. They had to go as what? An English subject, which is a servitude, a Negro, or black, or colored. They went in as a Moor to the legislature. They asserted their authority based on a treaty. The treaty was the thing. About doing that, you know what they did? They made a state passed the legislative act. Now all Moors that's in South Africa run a political jurisdiction structure. South Carolina cannot pass any laws against the Moors, whether they got cars and credentials, because what? Because a Moor did the right thing. He went to the legislative power, he enforced the treaty. That's why when you enforce the treaty, you were taking all Moors that's in that territory, not just yourself. So you go to court, y'all be the traffic ticket.
Say that again. One more again. One more again.
When you enforce the treaty, you're taking all Moors that go in and out of that jurisdiction as residents or national in and out of that jurisdiction, political jurisdiction.
One more again. One more again.
Now, when you do it individually, you've been taking nothing. You're not even taking yourself, because you get in that situation again, they're going to roof you. They're going to find a way to quiet you down, roof you by giving you all that time so you can't talk. Everybody else gets scared. I ain't going there and see having a Roy. They knock Roy off. They get Roy 20 years for a ticket. No, they get 20 years for a ticket. They get Roy 20 years and Roy out there operating de facto.
Let me slow you down, Shem. Let's slow this down. But you made very impactful statement. You talk with the power of Moorish treaties, the power. You said that when you were forced the treaty through government structure, you're not forcing it just for one Moor, for all the Moors in that territory.
Yes.
My brothers and sisters,
absolutely.
please, let's slow this down, please, my brothers. Please, my brothers and sisters. If we can just see the value of our national political unity. I know we've been instructed for over 100 years by conscious Moors, the individual upon individual upon individual upon individual upon individual cases. I know. But wow,
Come on, yeah.
the power of our national unity, treaty enforcement. I just want us to let that sink in, man. Just let it sink in. Because it taught was Shem, because of this over 100 years of individual, they consciousness Moors have been on this treadmill. This treadmill, individual. And we just gotta continue to push this, man. We can do this. We can do this, man. I'm about to cry, man, because it's been almost 30 years, 29 years next month. We're at 29 years next month. I've seen so many. I have not seen sustained growth. And the reason why I have not seen sustained growth is because of the misconceptions. We can have sustained growth. 1,000, 10,000, 20,000, 40,000, 50, 100,000, 200,000, sustained growth. You cannot have sustained growth with misconceptions. And I've been involved, heavily involved for 29 years, heavily involved. Go ahead, Shem.
Abdul, I know brothers that spent 9 years, 12 years being bounced around the county prisons just by the fact trying to go and individualize them and don't have no more counsel come and get them because they don't know they're going there without not protected by treaty or political structure. So let me speak about myself. They held me in there for 26 months. I'm talking about experience because we had a Moors government or no council. So anybody gonna come and get you when you go in the individual, because I'm gonna tell you what happened. They run the commerce. The moment you go in there and you got, right now you go on the stock exchange floor where they trade commodities and you go in and talk about you gonna do this, stop the trading. The man will hit the mallet, they can call for security, and they're gonna take you out and take you to jail. The moment you go in that courtroom to disturb their commerce, they're gonna lock you up. And you don't have a Moors government there, a council to represent you, they're gonna root for you. You be sitting in jail for 12 years and they don't have to bring you back into court. They all do bounce you around different county jails. And then when they get tired of this, they make it lose his mind, go crazy. I seen this happen to a brother Abdullah. Remember that brother I did to Abdullah? He did what he said. He did 9 years and then bouncing around because he went in the courtroom, waiving his right to Moors protection. He said, I had no government, nobody come and get me. Bouncing around different Moors county jails for 9 years. And then guess what? He came home and went back and doing the same thing. They were sending him back in there now. He mental now. He mental. His mind is gone now. He mental. See, this will happen when government structure is a lot. It's all government structure because, see, United States already set a subcommittee on foreign relations. They already got senators that's elected to pass laws and statutes that benefit international, nationals, and aliens based on international law, foreign agreements, and conventions and declarations. The thing about it is, they said they'll never figure it out because they're not taught this in school. Now, this is my thing coming about divinity. Everything comes to a woman, mother. That's universal law, feminine and masculine. Anything you want to grow comes to wisdom, the feminine. Like the earth, All the bugs, the weeds, the trees, everything come out of earth. That's the feminine, the mother. So mother, women are very important in this. Women get all the gifts. Anytime we got to get out of something, I believe it's coming through a woman. Because a woman that want to form that form, and the divinity go on her, and that divinity, all the resources come from the invisible world, like Abdullah said, in astronomy and geometry. When a seed, they met the genetic codes of a seed or seashell shape or how it grows or anything, fish or anything, is locked into a genetic code. Where it comes from, the powers of the unseen world, legislative power. They got government structure there. That means we in the unseen world right now. The government structure is running. The sun is going by government structure. The moon is going by a cycle of government structure. Stars, everything by government structure, unseen world. And the problem is, they sit when something go wrong here, unbalanced among us. We elected. We didn't want elected of the motherland. We elected from that descent. When something go wrong with us, the powers to be sent forth everything in the divinity in that woman's womb for the unseen world. It goes into your body shape. It comes out in that divinity. This is why we're going to lock the mystery. Without even going to college, we're going to lock the revelation and the redemption and plan to get out of this mess. This is very important. And if you're conscious more, if you want to protect your people, become conscious, acknowledge yourself, and let the other world acknowledge yourself, let the other world acknowledge you who you are. That's your inherent right. When you got government structure, you can't go wrong. When you don't have government structure, you're not helping all the Moors out. You're not even helping yourself, because the likelihood they'll come back around again and swing it bad, knock your head off, give you mental damage. They're gonna mess you up.
We have a hand up. We have a hand up. Akeem. Akeem. Your hand is up. Did it go off? What happened? Mike, where'd he go?
I don't know. I don't know. He's not with me. I don't know.
I'm saying his hand was up.
He's tuned in, but I don't know where he went.
Yeah. All right.
Anybody else got questions?
Any questions? Anybody have questions, comments, or criticism?
Okay, let's go back to the Oval Office.
Oh, he just
now.
Hold on. He just texted me. He said he got to reset his computer. He'll be back.
All right. Go ahead, Shem.
Okay, now, so we understand when the Moor goes into a courtroom trying to take his own individual interests, he's not Moor. That's number one. And what he's doing is he's expatriating himself because he asked the judge to hear a matter.
Hold on, Shem. You said, he all right. He is a Moor. He is a Moor. So that's hold on. That's because we don't want this out there on the tape. This is being recorded. Okay. It's gonna be on.
Anyone can be a conscious Moor or even unconscious Moor. If you're conscious Moor.
Let's qualify that though. Let's qualify it though. On the Shem. Let's qualify it.
A conscious Moor is the one.
No, we could. Hold on, Shem. Hold on, Shem. Hold on, please, hold on, because you're gonna have people. You're gonna have thousands of people that's gonna watching this, and they're gonna be learning about their nationality. So we want to be very clear that all our people are Moors. They never were black. They never were Negro. They never were colored. They never were Latino, Spanish, Dominican, Mexican, etc. They were never Indian. They were never ever that. They can never ever be that. Ever.
That's right.
Moor is their pedigree, their blood, ancestry, lineage, descent, genealogy, national origin. All right. What Shem is talking about, he's talking about political status.
Yes.
Right? Yes, we're Moors. That can never change. There's nothing, no paperwork, no Moorish government can't make that change. No England, Spain, Portugal, France can't make that change. We are Moor by consanguinity. This is very important. You're talking about a change in political status.
Yes. And that's what happens when you
Not in nationality, not in blood.
right, that's right, not nationality, blood. The moment is this right here. The moment that someone on the ideology and theory of that government, the methodology of that government of people, the moment they label you by language as outside of your consanguinity, that's not a change of nationality. That's expatriating you out of your birthright. In other words, that means you change your status. Therefore, by changing your status, your political status, you can't claim the birthright because you're not claiming any protection of your mother, with your motherland. So anymore, there's a conscious Moor. When you make a decision like that and can promote that, the more that's unconscious, thinking that, well, look at him. He went to the courts. They ignore everything he did. They ignore. They ain't gonna listen to that. Absolutely, they don't have power. They don't have the political power to have a situation dealing with a Moor because of their political status. He's a Moor, but by going in there claiming he's a Moor, but seeking protection or decision from that tribunal, that's an act of expatriation by expression. Expatriation means you decide to do something that normally your government set up years anciently through agreement that protect you. And you say, no, I'm gonna do it myself. That's called expatriate yourself. You change your political status. No longer want the protection of your government, you want the protection of that court. And that court is what? Is a creature of the state. And therefore, in order for it to hear a matter, you gotta be considered as a puppet of the state. What do you mean? A ward, or a minor, an infant? That's the name they got for you in probate. A ward, an infant, a minor, or a incapacitated person. That's why under the Social Security Act, it called people that's a black, color, African American as what? Special needy people. Why they call you special needy? Because you don't have no government, you don't have no economy, you have no protection, you have no government, so you're special needy, special care you, you're a ward of the state. So automatically you expatriate yourself by actions, by going there, asking that court to do something for you, when by international agreements, that court don't have power to hear a matter dealing with an alien. They don't have the power. They're not vested in their power. Congress, just like Congress designated circuit courts to hear on the diversity of citizen status, a statute, the Judiciary Act, a statute. The district courts, circuit court, the power to hear any dispute between two nations in the United States territory of the Union. Why that court can hear? By act of Congress. Now, Congress passed an act, a bill that gives an international organization to obey international law. So anybody that's a government official or government, they go directly to the State Department, to International Affairs, or directly to the organization. They ain't got power to assist you. And under the treaty, they assist you in international law. So whether you're conscious more, you're not helping the unconscious more, because all they're gonna look at you and say, well, he went dead. They ignore him. No, they don't know that the court don't have right to hear that matter anyway. So that's very important. When we do something, our actions reflect sometimes on a lot of other Moors that are unconscious, because they're gonna go by you. They're gonna go by evidence. Evidence on a scale. Evidence, the fruits of evidence on a scale. Show me your works. Look at the works right there that Moor went there, and they put him in jail for 10 years trying to force the Moor's right. I ain't gonna be no Moor. No, he can't see, you're not helping nobody. And the go there and say, well, I beat my ticket, or I went to my child support case. Let me explain something to you. If the council didn't go there, when you got government structure and council, you can take the people now. You can go ahead now, you go and make the people claim their nationality. The government can step up and protect them now. Doing diplomatic channels, diplomatic affairs. What you mean? That government will give a proclamation and notify. See, all the governments got a national information center. they put that proclamation in the National Information Center. All law enforcement officers get it because it comes to the Department of State, Foreign Affairs, to all law enforcement officers. They get that proclamation. Now, whether they obey the proclamation doesn't make a difference. Once council have jurisdiction, the more remedy. That's all it comes. Now you benefit all the Moors now. Why? Because they say, wait a minute, they got a government. Look at him. He stepped in and dismissed it, or they transferred it. That's why it's very important to make sure we do everything conscious the right way.
Shem, that is very important. I know you. I see your hand. Not Shem. That is very, very, very important that you continue to make that point of helping out. You're helping all your people out, and you do so because we got to get them to see the value of national political unity. And because of the individual, remember, they were instructed. They've been instructed upon through individual cases. They've been instructed. So what we're doing is getting to see the value, the power of national unity. So Nana.
All right, hold on one moment. Okay. Okay, so two things that I want to say. One is from earlier, and then the second one is based on what Shem just said. So I want to go to what I kind of always ask, and that is, in this land here, and then just hear me out, Shem, because I really want you to answer these, the two parts. Part one, who on this land is France, Spain, Great Britain, and United States of America in Congress assembled? And what do they have to do with us and amongst one another? And do they still exist? This is all, you already know the answer to all this. So
Terrence can answer that. Terrence is going to answer that. Terrence is going to answer that. Go ahead, Terrence. Terrence is going to answer that with detail.
So,
all right, this is on. Okay,
okay, let me finish. Okay, because we do a lot of interrupting, folks. Let
but can we do one question at a time though? Can you just ask one question at a time? And can we answer? You ask one question, then we answer it. So you're going to do it.
I'm not finished. Yeah,
you're not done your question. You're not done your first question.
Yeah.
All right. All right, go ahead. I thought you the first question. Go ahead.
Oh, see, when you interrupt, it stops the flow of what I'm trying to get out. And so I don't really know what the rest of what I was going to say is. So Terrence, if you want to go ahead, and perhaps I'll, during your explanation, remember what the rest of it was that I was going to ask, and then I'll ask that at the end of the explanation of Spain, France, Great Britain, and United States of America in Congress assembled, and also who is United States for the District of Columbia, which is from the Act of 1871. It's not that it's so many questions, it's all together. So I wanted to get a full comprehension of all of it.
But I'm saying give Terrence a chance to answer the question though. We got it. We got it. Give Terrence a chance to answer the question.
Oh, excuse me. I wasn't ready for that one because I am still working right now. I will leave that one to Shem. But
we're going to talk about the treaties. We're going to talk about the treaty because she's asking about. This goes to the treaty. In order for anyone in order for anyone in the world to answer the question, and only for anyone in the world to answer her question, they would have to go to the land cession treaties among them. That's the only way in the world anyone can answer her question. They have to go to the land cession 1763 Treaty of Paris between France and Great Britain. They're saying you got to break down the treaty. That's the only way in the world. If they don't do that, they're not answering your question. If they don't go, if you don't go, if no one goes to talk about those land boundary cession treaties, you're not answering a question. I know
Right.
I know what she's talking about. That's the only way you can answer a question.
And
So that's saying
then on top, and then on top of that, how if those places were here, what they're called or here, what were they called before that, and how did they get their names? That's kind of, it's all in, all in the explanation. So
all right, those are not places. Those are not places. And let me explain. I'm gonna explain.
So let me ask you a question, Abdul. Are you going to explain all of it, or are you going to have Shem? Because I'm not sure.
Sister, let me answer your question, please.
Yes, go ahead.
Just give me a chance. Just give me a chance to answer the question.
I'm quiet. I'm being quiet. Just answer.
Go ahead, you got the floor.
I know you got the floor.
All right. So one, they're not places. When there you got intricate terra divina. So we got what's called territorial sovereignty and dominion. So Spain, Portugal, France, Sweden, the Netherlands, England, Great Britain extended their territorial sovereignty and dominion on Moorish land. Those do not become places. They create what they do, surveys and create political survey maps. So if you Google right now, 1600s, what 1700s, and you see, you see France and Spain, and all right, those are not names of places. That is Spain. All what you see is Spain, France, Portugal, the Netherlands, England, expanding their territorial. That is just outlines their territorial sovereignty and dominion. They don't become places. The 1923, just give you an example. The Osman dynasty. The Osman dynasty was a house. The Osman house was established in the 1200s, and it became more power to an empire. They known as the Ottoman Empire. That Ottoman Empire, Osman house or dynasty, was dismembered through the Treaty of Lausanne. The Treaty of Lausanne, 1923. That treaty is up next year. That dismembered. So when you see these different maps, 400 years ago, 300 years ago, all right, those are never names of places. You have European power changing the territorial sovereignty is being under control of another state or kingdom. Those are not names of places. So it's going back to this is on Crumb TV, Moroccan Post on Crumb TV. Also got this on the we did a 3-part series on the power of Moorish treaties and the powers of what's it called, Terrence? The power of Moorish treaties and the recovery of lost Moorish sovereignty. This is on the Moroccan Post Media YouTube page and Crumb TV YouTube page, Moroccan Post Media YouTube page. I did a 3-part series, and this is all broken down. Watching the 3-part series will do you justice because we go into detail where you see the maps. We also the wars. You have the wars and the years. That goes into detail. That's the only way anyone in the world can answer. So it's understanding international law. So that's called territorial sovereignty. So when that happens, so now you have New Jersey. New Jersey, that's not a place. New Jersey, that is the New Jersey colony. New Jersey colony, and in the New Jersey charter, the New Jersey colony, that was a proprietor under a proprietorship of 24 proprietors. There was 24 proprietors who were granted a charter. And in that proprietary charter, New Jersey colony is that laid out the survey in that charter, the 1763 Treaty of Paris between United States and Great Britain. Now, New Jersey, so that same in international law is called juris posteditis, a posteditis juris. Posteditis juris, which means that the seceding state takes over the same territory of the predecessor state. Posteditis juris. And in the New Jersey Colony Charter, it was East Jersey and West Jersey. And 24 proprietors. North Carolina, Georgia. Georgia was a proprietary colony. Now you have New Jersey State. New Jersey State, New Jersey Colony. So the same land that's surveyed, that's in the colony, and that colony charter, New Jersey State is operating that by virtue of the Treaty of Paris between Great Britain and the United States. This is how you answer the question. So go once again for everybody, Moroccan Post Media on that have that 3-part series, and then there's also the Trump TV. And that's a great question. So be very clear that once you understand that, you will know that they're not lands. They're just exercising, extending their territorial sovereignty and dominion, as we did, as the Moroccan Empire extended her territorial sovereignty to Phoenicia, North Africa, West Africa. So that's how you would answer the question. But because we haven't studied on this level, we think they're places. I yield.
Yep, they all are
And I would like to-
political territory. The political territory.
I'd like to
The
show a couple of,
political territories.
Okay, another question, like just to follow up with that one so I can get to the second part. That was a great answer. I knew someone would answer it like succinctly. So yeah, I knew most of the answer. But you added some other things that I didn't know. And so those people that were extending their territorial, sovereignty, were they Moors? Were they mulattoes? Who were they that was doing that? And then I can go to my second question.
All right, let me answer that. All right. If you look at the there's a book called a 2-volume book. I like to give doc evidence. I don't just like to just talk. There's a 2-volume book called the Ancient and Modern Britain. Ancient and Modern Britain by David McRitchie. And he goes and David McRitchie chronicles the Danes, all right, in different parts of Phoenicia. The Danes and the Moorish rule in different parts of Phoenicia. The progenitors of the Scottish and Irish clans look like me. The progenitors, the Irish Scottish clans, the Celts. You have also in the coat of arms, the coat of arms of aristocratic European families. J. Rogers' book, Nature Knows No Color Line, chapter 6, the Negro as Moor in European aristocratic families. If you will also Google, you'll see Moors in a coat of arms, and all throughout Phoenicia, in Sweden and Dutch and the Netherlands, and southern Europe, Russia. and you also see statues. Saint Maurice, Wesley Snipes looking complexion. Saint Maurice, the patron saint of an entire country. If the patron saint of an entire country is Wesley Snipes looking, Wesley Snipes complexion. Of entire country, Saint Maurice. I gotta present it that way. I have to present, so you can, look at, the presence, the rulership. There's also a book called, a 3-volume book called the Moorish Empire in Europe, the history of the Moorish Empire in Europe by S.P. Scott. And it's also Macquarie, in that was 1893, volumes 1, 2, and 3, the history of the history of the Moorish Empire in Europe, volumes 1, 2, and 3, and then book that was put out in 1850 by Macquarie is 2-volume book, the Moorish something in Spain, Moorish Empire in Spain, volumes 1 and 2 by Macquarie. You also have the book called The Black Athena, Martin Brunel, The Black Athena, volumes 1 and 2. You have the book titled by Frank Snowden, Black in Antiquity. And Frank Snowden has 100 photos of busts, figurines, masks, and you can actually see when they show the busts and statues that look like Europeans, they look new. But when they show busts and figurines that look like us, they're old looking. But the ones that look like Europeans, they're polished, they're all new looking. That's something to look at. Just analyze that. Vases and all that. So because we've been indoctrinated with the false images, because they control the schools. So do you mean Europeans don't need, what I'm saying is, when they say, well, only like the Afrocentrics, quote unquote Afrocentrics people, quote unquote Afrocentric people, they'll say, only white people history is taught in schools. No, that's not, no. European history is not taught in schools either. No, that's a lie. To say that only, because they'll say white, only white people history is taught in school, that's a lie. Their history is not taught in schools either. When the history taught in school? St. Joe's University. European history is taught in St. Joe's University? Temple University? No, it's not. European history is not taught in these schools. Our history is not even taught in these schools. So their history is not taught either. Let's put this in proper perspective.
Can I ask my second question? What's that to do with government? That was great answers. Those were great. All of what you said, Abdullah. Thank you so much. Look, I'm trying to write the books down fast enough.
The Moorish, the history of the Moorish Empire in Europe by S.P. Scott, volumes 1, 2, and 3. Nature knows no color line. Chapter 6 of that book is entitled The Negro as Moor in European Aristocratic Families. J. Rogers shows over 100 coat of arms and crests with dark olive Moors. There's also 50 names that derived from Moor and European languages. M-O-H-R, M-U-I-R, M-A-R-E, M-O-O-R-E, M-U-R-E, so you got 50 names. So this is very important information. There's another 2-volume book, the
What's the name of the
Ancient
chapter?
and Modern Britain by David McRitchie. Volumes 1 and 2. Yeah, because this reading is important. That way you build up your knowledge base and you have references to pull from. Black Athena by Martin Bennell, volumes 1 and 2. Blacks in Antiquity by Frank Snowden. He has 100 photos of masks, busts, bases, and figurines. And there's another book by Macri back in the Moorish rule in Spain in 1850. He was written out by Macri. You also have the what's it called? The Moors in Spain by Stain Lane Poole, Moors in Spain. And you have Moors after Spain. You know, Moors after Spain is more on Moors and Masonry Part 1, you know, and I go more detail with that because I have more treaties listed in there and Moors and Masonry Part 1. So you have Moors and Masonry Part 1, all right? Moors after Spain, all right? I'm gonna put my book in there, Moors and Masonry Part 1, Moors and Masonry Part 1. So it's important that we provide sources, references. I have over 100 references in Moors and Masonry Part 1 and Moors and Masonry Part 2. I make sure that I have references. I loaded up the sources in there. All right. Sister, we have other hands up. Akeem, are you back with us? Akeem, you're back. Your hand was up. We called on you. All right.
Peace and love. I was just having technical difficulties. My apologies.
Mm-hmm.
I just had a question about what Brother Shem was talking about, treaty enforcement through the state legislatures. And I was wondering if Brother Shem could elaborate some more on that, treaty enforcement through state legislatures. He had particularly mentioned a case where the South Carolina Moors. Talk about that a little bit more.
Shem.
Yeah, right here.
All right, you hear the question?
Yes, you said you want to elaborate on the Son John Moore Act about the treaties. Now, let me explain something to you. The Moors that got kidnapped by the African kings. What happened was the African kings put them on a ship, an American ship, so they could go back and they get ransom for their freedom. The council, actually, the council is supposed to be the one that spoke for them, represent them with the United States United States Department of Foreign Affairs. What happened was, or United States Council, what happened was when they got to the state, they never got a chance to deal with the council because the state took them in as servitude, as slaves. I'm not slaves, they put them as slaves. Or otherwise, they put them in servitude, slavery. They took the Moors and sold them in slavery when they got to the ship. And what the Moors did was they negotiated their way out of servitude by purchasing their freedom back. And when they did it, they made sure they went to the legislature of the state. First of all, they want to make sure that they won't be considered as Negroes or black on the black Negro codes, the Negro codes. And by doing that, the legislature of the state had power to pass law. I mean, based on the agreement that they claimed that there was nationals of a government that's in allegiance to the United States. What the state did was obey the supremacy clause. The state went by the highest order of law and took that petition and honored it and looked at their status. And by law, the states realized that they Moors, that was made by claim. It wasn't made, the state didn't say they made them Moors. They made that by recognizing who they were already. And what the states did was because the council never came up for them. So they went to the state to petition their rights as a Moor based on a treaty. Remember, the main key thing was a treaty. They claimed to be Moors and they went under a treaty. They didn't go under a state law or United States statute. They said we're in a treaty with the United States. Our prince, our emperor, entered a treaty with the United States, and we foreign national. What happened is the state of South Carolina honored that based on their status of the treaty, not because they when they're saying they want state rights, they were based on the treaty. So as we can see, everything dealing with a Moor put it based on a treaty.
Correct.
See, remember now, Africa put them on a ship so they could deliver in America, so the Moorish Council can assist them. What happened was they forced them in servitude, never got a chance to notify the council because they were forced in servitude. I mean, they're forced to be in slavery. So you can see how it goes. And they didn't wait. They didn't expatriate themselves. They didn't go to the state asking for permission. They didn't go to the federal courts. They went straight to the legislature and say that they forced the treaty. Now, somebody said, well, they did it individually. Well, let me explain something to you. They were sent to America to be ransomed. They was kidnapped. In 1790, for Moors to be kidnapped and brought back to America and sold in servitude and purchased their freedom, negotiated their freedom, and that's a pattern of good works. The first claim they made is that we nationals of a foreign emperor that's in allegiance to the United States. That's a claim they made in a petition to the House of Representatives and the Senate. And they looked at it and they realized that there was foreign nationals. They was taken in servitude by Africa and placed on a ship, and they were sold. First of all, they were sold. That did the treaty by protection away. Is the fact that they claimed government structure. What do you mean, Shem? Government structure. They claimed that the treaty was signed by a Moorish emperor, a government structure. They had protection in that treaty. And what was South Carolina honored that and gave it and granted their petition based on the treaty.
Okay, so may I ask you this question then, Brother Shem? So being that took place in the British Dominion political zone, South Carolina, and so the United States, in their constitution, they have under Article 4, Section 1, the full faith and credit clause. Could that sundry act be enforced in the other states as well because of the full faith and credit clause?
No. It's enforced in the political jurisdiction of the state of South Carolina, based on the treaty. Now, and there's a law enforced in all states based on a council's jurisdiction, on international conventions and treaties and declarations that the United States ratified, the president signed and the Senate ratified. So now the international acts and stuff will be enforced by organizations the United States set up. In the State Department, there's an Office of Foreign Affairs. In the Office of Foreign Affairs, the United States had elected foreign organizations to hear all disputes. I mean, they got the central authority to deal with foreign policy, to hear all foreign disputes, deal with treaties, conventions, council, the jurisdiction. So that organization is called, it's an organization in the State Department of International Affairs, and they got the power now. So everything changed now. Well, all nations got together as an international council. All nations that come to the UN that's the International Congress. And once they pass something, once that delegate of the state or nation that's a member of the UN, once they sign it, and that agreement go back to the government president sign it, and the head of government ratify the parliament, that becomes law inside any country or state based on what? As customary law. It becomes law because the head of the state signed that, ratified it, and the head of state, president or governor signed that. So now that becomes the law of that state as if they were passed by their own legislature. Why, Shem? Because what that Congress of the UN is the International Congress. And the head of state signs it and confirmed and ratified by the head of that government automatically get enforce that international law. So happening is in the United States, they got an international agency and the Department of Justice. They hear all the matters of foreign affairs. They hear that matter. So the council got to get notification to let them know that there's a Moorish government up running, and what the council notification is up. The council got power to come in and invoke the council court, and the council got jurisdiction to hear the matter. And the matter cannot be appealed to any court of that state. It can't be appealed. Yes.
Yes, Brother Shem, I understand enforcement through consul and through consular jurisdiction. I totally get that. What I'm saying is within the British dominions, the political zone of the United States, they have in their constitution the full faith and credit clause. And it states in that clause that each state has to basically respect every other state's public acts. So that act, the Sundry Moors Act, that public law that they passed in South Carolina, that has to be basically respected by, for example, New York State or California State. Like they'd have to.
No, that's not true. That's not true. You know why? Because if one state legislative body pass a law for their state, that law, that bill will only govern in the jurisdiction of that state. No other state is obligated to force that bill and law on the other state because the citizens, they're not elected as officials, they're not elected as government body. Only people only government officials that are elected by the population of their state got power to make laws and acts and enforce in that Jewish territory.
Right. If I may,
The United States is given the head authority by all the states when they form the Constitution. Congress has been given the inherent power, so all the inherent powers in Congress. The inherent power is not in the state legislature, only in the jurisdiction of that state. But the United States, the federal government, have exclusive jurisdiction in all the states, based on what all the representatives of the government sign the Constitution and agree to represent their state in a central body government. The central body, national government, is the only one authorized to make into treaties, the allegiance, and enforce international contracts in all the states. Because all the states gave their sovereignty when they signed that Constitution. They gave it up to one central government. You understand what I mean?
Right. And if I just may interject, Akeem, the full faith and credit clause does express, the judicial acts, judicial proceedings and records.
Public record in the state.
Right. And
you want to do the public record, that's all the state. That means that anytime in the public record means that the state passes a law or the courts make a judicial decision of that state or any kind of record, anything placed in the record, full faith and credit to be given. I'm gonna say what I mean. When Sundry Moors took that petition and gave it to the legislature, what they did was, based on international law treaty, the petition became what? Full faith credit of the United States authorities signed a treaty with a foreign nation, and that they're obligated to that agreement, that treaty.
Right. I was just no. For clarity, I was just saying to Akeem, the full faith and credit clause applies in particularly, as you know, each state is saying it's essentially sovereign, as it pertains to their own statutes and codes and stuff that they enforce. Obviously, they differ from each other. However, with the full faith and credit, the full faith clause of Article 4, what it stipulates, what it means is that it's basically identifying that every state is obligated to uphold whatever it is that has been enforced or passed in one state. For example, ironically, the only thing that really seems to be upheld in that full faith and credit clause is when it's dealing with judicial proceedings, although it says acts, public records, and judicial proceedings. So, for example, if you catch a charge, let's say the New York State political zone. Now, if there was a court order, saying for whatever sentencing for that, let's say the assailant, makes it to New Jersey or Delaware, Maryland. The authorities in Maryland have to honor what was upheld in New York State, and they have to extradite him back to New York State to be prosecuted and therefore to finish out his sentence or her sentence. That's what the full faith and credit clause is usually carried out, executed for in judicial proceedings in particular. So,
The federal registry, United States got the federal registry. What that means is that the United States taking place a statute or act or bill to enforce international law, goes to the federal or code, it goes to the federal registry. When it goes to the federal registry, that's the public record. Now, when if a council say, hey, listen, you have to get audited full faith and pledge to the public record. That's in the archives of the state, of the federal government. That's the federal government, the state within the union state is a central government. So any acts or anything that the federal government passed will become public record in all the states to the federal registry. You understand, Hakeem?
Yes. I'm just, I guess, a little confused on the full faith and credit clause and why they would even mention public acts if the Sundry Moore Act isn't able to be enforced across the industry.
No, it can be enforced, but it got to be enforced in North Carolina, in South Carolina, because that petition was granted and the act went out. So therefore, the act is part of the public record of South Carolina. So full faith and credit got to be given to the public record of every state. If it's a court action, if it's a legislative act, or it's a policy, any kind of policy or orders of a county, it got to be considered a public record.
Right. I think what I see what Akeem is referring to, and then he's kind of like zooming in on that particular issue, because I think he's recognizing this. Like I said, they mentioned public acts, they mentioned public records. However, they only carried out the judicial process of that clause, and that's and like I said, and then I think that's just really, I don't know if it's a coincidence, but it just seems like that's the matter of affairs that end up pretty much happening by default. Is that that's why you always have extradition issues or handling offenses. For example, a brother I was helping with a case one time, he was domiciled in the New York political zone, and he was going to move. He had a criminal case. What they did was, they allowed him, the court allowed him to now, move, to another state. And what it was, they just carried out his sentence in another state. Now that would be an example of full faith and credit. The reason why the court was able to do that is because they was able to send the paperwork from New York to the other state to carry out his sentencing under the full faith and credit clause. That state was obligated to carry that out.
We do it all the time. A man on parole in one state, he going to transfer his parole to another state. What happened is that state into what you call international agreements between small agreements between each other to transfer the prisoner to one state supervision to the other state supervision. And once that agreement goes to that state record, that's a public record. They can't send to another state that they agreed to do his time at the supervision incarceration. So that's in the public record. All full faith and credit are given to the public record in every state. That means what's on the record of that state, the other state is supposed to respect that. Meaning that if it's passed by one state, that means if it's in the public record by the state can't go against that. It's full faith and credit. They get full faith and credit. But like I say, in the federal registry, all the codes, the statute, regulations, the statutes are passed based on by the federal government, and therefore that's the international registry, the federal registry, and through all the states. Once that goes to the federal regulatory archives, that's full faith and credit in all the states. Why? Because the federal government is the supreme authority of the central government of all the states. So the federal registry is full faith and credit, got to give it to that federal registry. The code, statute, and regulations of international law, give it to that, the public registry. That becomes the public registry of all the states.
We have S. Murray Bay. S. Murray Bay.
Islam. Can you hear me?
Yes.
My question is, isn't there like an international law that says that like foreign nationals can't interfere with the internal affairs of another nation? And us being foreign nationals, we can't interfere with how they run their commerce. I mean, we'll be able to probably do it once we get in our government and do, you know, and magistrate their commerce in Morocco. But right now, we can't interfere with how they run their internal affairs as foreign nationals. That's what I understand.
Well, here's the thing about it. It's not running the commercial affairs. The fact that there's an international agreement and it's being enforced through federal law. And what it is already, once the state interferes with international law, this is some of the commerce of the United States, of international community. Therefore, that's why it's a law of the land, the treaties, international agreements. You're not interfering with the state commercial affair because the state is obligated to follow it. Once you go to the federal registry as the law, code, or statute, that's the public record. They got to give honor to the public record, the federal government, because the federal government is the only one in the Constitution given the lawful authority to treaties. The state can't do that. So when the states don't go with international law, they interfere with the United States commerce and the world government commerce. So it's not disturbing their commerce. What it's doing, they're living up to in other words, they become debtors. They're living up to the jurisprudence of honor agreements. That's why it's very important. He said no one should pay the obligation of contract. The states cannot put the obligation of the United States into contracts and treaties with other foreign nations. When they do that, come on, interfering with the judicial power, they interfere with what they're doing is they turn around and pay the obligation of contract. So they violate their own constitution. So you're not interfering with it. You're not interfering with nothing they're doing if they can't impair the obligation of contract and treaties the contract. So the United States made it clear in a case that once the federal government signs something, the head government sign a treaty or convention, that becomes the customary law and domestic law inside the state, as if the state passed the law itself. It becomes the law. So when they don't follow that, they're the ones causing the commercial disturbance.
Right. And S. Murray Bay, let me give you a case law, Colavrat versus Oregon, which stipulates a state cannot refuse to give foreign nationals their treaty rights because of fear that valid international agreements may possibly not work completely to the satisfaction of state authorities.
Yes.
Could you text that to me, brother?
Oh, Mike,
No, hold on, Mike. No, we don't do the personal. No, hold on. We don't do the personal. No, we'll never do that.
Right. I gave him the case law. It's spelled KOLO.
That's for everybody. We're speaking to everybody.
Right.
I'll put it in the chat.
Thank you. Yeah, we don't do the personal. We're gonna put in the chat. This is for everybody.
Right.
For everybody.
In that case, Mike. You read it? I said, Mike, you read the case I sent you on. You read it, huh?
This wasn't one of the ones that you sent me, brother, but I did read. This is one of the ones I've got on my own recon, but I did. I'm still catching up to your cases, brother. But this one.
We have other people. We have other people that want to ask questions. So just put them in the chat.
Any more questions? Right. Any more questions?
Yes.
Akeem is going to send it to the brother and put it up in the chat for everyone.
Any more questions?
Okay, I was just waiting for them to finish. That was a good discussion right there. So back to government and what all government should have in order to, I guess, be officially a government. Would that be a flag, a post office, a bank, a currency? Can someone elaborate on that so that we know?
Let me talk on that. Shem and I had a conference call yesterday. I'm gonna do what I did yesterday. We had a conference call yesterday, and before we got into the seven steps to forming a Moorish body politic on the Moroccan Post Media YouTube page, there are 12 Moorish body politic formation classes, and then we also have the 7 steps. We'll put your email, everybody put their name and email in the chat too. We can send that out. And then we had some other stuff. But before we went into, in fact, we didn't even get into the 7 steps because I spoke in detail on political legitimacy and the consent of the people. Before we get into forming anything, you need a population. So you need to reach, so the first step is community outreach. Community outreach, because we talk about political legitimacy, the consent of the people. So that's very important to deal with, facilitate community outreach through political legitimacy, the consent of the people. Without that, there's no authority, because the authority, can you hear me? What's going on? What's going on?
Nothing, go ahead.
Hear you.
I hear you, Abdul, I hear you.
All right, the authority comes from the people. You have the term, we the people, the people. We the people, and we have the term, the people. Those are 2 terms, and what that means is the repository of the collective sovereignty of the people vested in a constitution. The collective sovereignty of the people, of a society of people, that's expressed in a national written constitution. When one is elected to an office that is drafted in a constitution that comes from the authority of the people through a constitution, that natural person who is thereby elected by a population of people, of voters, that natural person holds that office in trust. That office does not belong to the one who's elected. That office belongs to the people. The one who's elected is the public servant. The people don't bow to you. What are they rising for? No, you rise for the people. Please rise. You better not rise. No, you ain't rise for them. You're not rising for no public official. The public official rises for the people. We don't rise for no public official. That's a misconcept. Hold on, the people are the boss. The people are the boss. So you hold on. So the boss, the people, are rising. The boss, the people, are going to rise for who? No. You're the boss. The people are the boss. And I'm speaking this way because it's very important to understand. I'm speaking this way conceptually. Speaking so we can get the concept. So we have to facilitate a population of people as voters. How do you do that? You need to do community outreach and set up classes, i.e. classes, this, all right, even bring them onto this platform, which other people have done, or even share the links to them, with them. So before we get, we haven't gotten to the 7 steps yet. All right?
We have
This
Brother
concept is very important.
We have Brother Vernon Watson. And just real quick, I'd like to say, Abdullah, you touched on a very important point when you were talking about the government. I see that a lot of Moors, many Moors actually put the government before the people. And I see that a lot. And that's a misconception. They try to build a government and without the people, and then try to bring the people in to the government. Like, it don't work like that. So please repeat that.
Yes. I thank you for making that point. And we definitely see that a lot. is people trying to, because that's the concept is even, I mean, to build a government without the people, therefore it's not a government. You're right, T. It's not a government because and if you're talking government, you're talking consent of the people. It's because that's the people. You say the government. Government equals the people. Government equals the people. So there's been a lot of misconceptions, and that T was speaking to that. So once I said there's a term in political science, I want y'all to look it up, political legitimacy. Political legitimacy. It's the consent of the people. You need the people's consent. How you say you this? I'm brand this. I'm this. I'm president. I'm prime minister. And then you also have conscious Moors claiming to be, head of a national Moorish government. Huh?
National federal government. National federal government.
The last national election on Moorish soil. The last national election on Moorish soil took place in 2020, November, the first Tuesday in November 2020 was the last national, I didn't say Moorish, last national election. Now, that wasn't a Moorish national election, but that was a national election. That's the United States presidency. So when was there a national election, a Moorish national election? Like, how you got a Moorish national government with no constitutional convention, with no national campaign, with no national elections, just like they had, Donald Trump and Joe Biden were running, they had, booths all over. Where was that? Misconcepts. And this, so somebody claiming to be an emperor, such empire. I mean, I've seen this for almost 30 years. Misconception upon misconception upon misconception. So, we've been we're going to continue to address misconceptions. Shem, you've done a great job tonight, brother. You still with us? Did he cut out? Shem cut out, right? All right, so what we'll do is
I'm here, more. I'm here.
All right. How long you gonna be with us, man? How long you gonna be with us tonight?
About 10 more minutes.
All right. So as we got Vernon Watson Bay. All right.
Islam. Once we get to the point where we recover more sovereignty and restore Moorish national government, right? I see the benefits of it, like the fact that have national unity and a national political unity. I see the benefit of all Moors being protected under that structured government, and I see the benefit of us being able to vote our consul rights, right? What other benefits are there to this recovery of more sovereignty and restoring more government?
All right, let me address that. Let me first give you the Shem Malachi base plan, and we're also working with El Kanan. All right. Shem Malachi base plan is taught to the Moorish and Pure Restoration Caucus 3.5 years ago, is to facilitate a Moorish intergovernmental alliance among the various Moorish body politics. We have been working to facilitate even body politics with classes and so forth, the various Moorish body politics, including the Moorish science temples. All right. And then we'll also be bringing the Masonic orders in and coming under this national political structure so that we can facilitate political legitimacy through a Moorish intergovernmental alliance, meaning that the heads that are elected by their body politics will send, to a convention whereby we will sign an instrument where that will be an agreement to form this national political structure. Now, it can only be provisional. The reason why we're talking I'm talking political science and international law and also political philosophy. It can only be provisional, which means temporary, because in order for a permanent government to be established, we need the millions of our people. So in a provisional status, maybe be for 2 or 3 years, we can address in the international arena crime against humanity. We can address colonization of our land. We can address the mass denationalization of our people as a national political unit. Also, part as being a provisional government, we'll put in there where we will be facilitating massive community outreach, so that whereby we can facilitate a plebiscite, means plebiscite, pleb people, site vote, a plebiscite. But you need more numbers, but we don't need millions of our people to form this Moorish intergovernmental alliance. The Moorish intergovernmental alliance will allow us to address issues in the international community as a provisional government. We must understand political science, international law, and political philosophy. Keeping in mind the consent of the people. No, y'all, when I claim to be a permanent government, y'all, we know y'all unconscious. We're speaking for y'all, all right? So we have to address this, because we have to respect the voice of those who are unconscious. Because
I gotta go, y'all. I gotta go.
All right, go, Shem.
All right.
All right, peace.
Peace, y'all.
Thanks,
Peace,
Shem.
more.
Peace.
So we have a plan in place. This is part of the plan. This class is part of the plan. All right. There's other study groups of body politics that have been part of this class, and that we have already reached out. We're reaching out to other body politics, Masonic orders in large numbers. All right. So we're very serious about this. But education is major. All right. So what we're going to do now is, Amanda, are you ready to? We can have by series. Are you with us? Are you still with us? We can share some reading now. Terrence, go right to the Terrence is going to pull up excerpt of the United States Counter Memorial in the 1952 case. The 1952 case was initiated by France. France signed a memorial in international law to start a case in the International Court of Justice. It is called a memorial. The United States had 6 months to respond with a counter memorial. That counter memorial is 600 pages long. I took 10 pages out of that 600 pages. It took me a while because I had to, comb through it, and then, maybe 10 or 20 pages of that counter memorial. And we're going to start reading some of that. We're going to start reading. And in that, what we're going to read, this counter memorial is very good detail. So I took out the part that dealt with the extraterritorial /compensatory consular jurisdiction clauses. All right. So you have this will continue with what Shem was talking about, so we can actually have some data. Put your name and email in the chat. We will email this to you. Put your name and email in the chat. We will email this excerpt of this counter memorial. You don't want the 600 pages. It's just a lot. I mean, you can Google the 600 pages. This is just the 10 pages of it, something that's manageable. All right, because this is the meat of it. I took the meat out. you know, that will address issues that we're dealing with tonight. All right. So we're going to have by series, are you open to reading? Terrence, you go
Yes,
right to the
brother. Yes,
memorial.
brother. Yes, brother.
Go to that section, Terrence.
Okay.
All right, there we go. Finish, by series.
All right. Excerpt of the United States 600-page counter memorial to France's memorial filed in the 1952 case between France and the United States in the International Court of Justice, ICJ. Capitulatory extraterritorial consul jurisdiction treaty clause from various treaty negotiated during the 1600s, 1700s, and 1800s. Article 9 of the treaty between Morocco and France, September 17, 1631. The treaty recognized extraterritorial rights of jurisdiction to the French consuls so far as concerned disputes of any kind among their nationals, that all differences which shall arise between the French Christians, whether of justice or otherwise, the ambassador who shall rise in our said kingdoms or consuls shall terminate them unless they wish to come before us for whatever the damage might have been. The extraterritorial jurisdiction already provided in Article 9 of the Treaty of 1631 was restated in clearer terms in Article 12 of the Treaty of 1682. And said consul shall have all power and jurisdiction over the differences which shall arise between Frenchmen, and the judges of the said Emperor of Morocco shall not be able to take cognizance of them. Article 13 of this treaty, in addition, contained a significant development in the field of extraterritorial jurisdiction. It dealt with difference arising not between French nationals, but between French and Moroccan nationals, and provided a special handling of this sort of case. If there should arise some difference between a Frenchman and a Moroccan, they shall not be judged by the ordinary judges, but instead by the council of the said Emperor of Morocco, or by his commandant in the ports where said differences arise. The Netherlands, following the lead of France, concluded a treaty with Morocco on May 26, 1683, which paralleled quite closely the treaty concluded by Morocco with France in 1682. Article 14 granted freedom of commerce to Dutch traders, and Article 15 recognized the exclusive jurisdiction of the consuls of the Netherlands over disputes of any type, civil or criminal, arising between their nationals. The subjects of said Netherlands, whether Christian or Jews, shall be asked in case of pleading or suit in the states of his said Majesty to submit to the jurisdiction of this country. But if there should arise some difference, whether civil or criminal, between those of the country of the Netherlands, in that case, they shall not be obliged to appear in front of any judge except their consul, who shall have entire authority to terminate all the differences in the civil as well as in the criminal, such as murders, wound, and other such offenses. Article 16 of the same treaty, however, reserved the jurisdiction of Morocco over criminal cases arising out of incidents between nationals of the Netherlands and Moroccan subjects, and not mention was made of a special handling of civil suits between Moroccan subjects and Dutch nationals. Thus, Article 15 of the treaty concluded in 1683 by Morocco with the Netherlands provided. But if there should arise some difference, whether civil or criminal, between those of the country of the Netherlands, in that case, they shall not be obliged to appear in front of any judge except their consul, who shall have entire authority to terminate all differences in the civil as well as in the criminal. Article 9 of the treaty concluded by Great Britain with Morocco in 1721 read, if any quarrel or dispute shall happen between any Englishman and a Mussulman, by which hurt to either may ensue, the same to be heard before and determined by the emperor only. And if an Englishman who may be the aggressor shall make his shall make his escape, no other Englishman shall suffer upon his account. And if Englishmen shall quarrel, to be determined by the English consul, who shall do with them as he pleases. Article 12 of the treaty of 1767 between Spain and Morocco stated, for the contestations among Spanish nationals, civil as well as criminal, their consul alone shall be competent. Article 16 of the treaty concluded between the Netherlands and Morocco in 1777 provided the subjects of the Estates General shall thus, in the event of disputes which may have arisen either civil or criminal solely between those of the above mentioned Netherlands nation, not be required to appear before any other magistrate than their consul. Some treaties did not refer expressly to criminal jurisdiction, but indicated by their context that the inclusion of both civil and criminal cases was intended. This was the case of the Spanish Treaty of 1799. Article 1 of this treaty, Annex 17, expressly renewed and confirmed all the privileges granted to Spain in the Treaty of 1767, and thus renewed the specific privileges of civil and criminal jurisdiction granted in Article 12 of that treaty. For the contestation.
Hold on, all right, serious. Let me stop you real quick. For can Amin TLC TCL A3, the Office of the Consul General, Jaden and Joanny Bay, can y'all text me your number? My number's in the chat. Abdullah Bay. My number's in the chat. Just text me. I have everybody else's number. That's Amin AMIN TCL A3, the Office of the Consul General. Ras Bay, that just came on. Ras Bay, the Office of the Sheriff, and Rafi Il. Can y'all text me? I'm Abdullah Bay. My number's in the chat. All right, so I can have your number. All right. Thank you. Go ahead, by serious. Continue.
All right, let's see, where was he? For the contestation among Spanish nationals, civil as well as criminal, their consul alone shall be competent. Yet Article 4 of the Treaty of 1799 did not expressly mention criminal jurisdiction, but stated the Consul General of Spain, Vice Consul or agent shall decide with absolute jurisdiction the affairs of Spanish nationals in Morocco. In like manner, the treaty concluded by France in 1767 has been construed by the French government itself, despite the absence of an express provision, as equivalent to a grant of both civil and criminal jurisdiction. In the treaty concluded in 1767 by Morocco and France, Article S, it kind of went blurry, bro. Article S did not specify whether criminal jurisdiction was granted and merely referred to the rights of the French consuls to hear and decide the differences arising between French nationals. The French government has listed this article in its memorial in support of the proposition that foreign consuls had exclusive jurisdiction before 1836 to decide all differences arising between their nationals, memorial page 33. In support of the same proposition, the French government listed as well articles, I think it's 12 of the Spanish Treaty of 1776, which provided for the contestations among Spanish nationals, civil as well as criminal, their consul alone shall be competent. Since Article 12 of the Spanish Treaty specifically provided for civil and criminal jurisdiction, and since the French government relied on this article to show that foreign consuls had exclusive jurisdiction to decide all differences arising between their nationals, it must follow that the French government itself construed the word differences as including both civil and criminal cases, and thus conferring both civil and criminal jurisdiction. A similar reasoning applies to the construction of the word differences in the French Treaty of September 17, 1631, especially in view of the fact that the only other treaty concluded by Morocco during the 17th century was the treaty with the Netherlands of 1683, which expressly indicated that differences refer to both civil and criminal cases. The wording of the jurisdictional provisions included in the treaty concluded by Morocco with Denmark in 1767 also leads to similar conclusions. Article 14 provided, if there arise a difference between a Moroccan and a Dane, the emperor shall decide it, or the governor of the place where it will happen, in the presence of the consul, who shall defend his cause as he may. The right of the consul to defend his national in the Moroccan courts are characteristics of criminal cases arising between foreigners and natives. Thus, the French Treaty of 1682 provided in Article 16, any Frenchman who shall hit a Moroccan shall not be punished until said consul has been called to defend the cause of the Frenchman. The French Treaty of 1767 contained an identical provision in Article 13. Article 14 of the Danish Treaty therefore used the word differences to describe criminal cases. Difference accordingly describe criminal cases as well as civil cases in Article 15 of the same treaty, providing, and if there arises a difference between some Danes, whatever it might be, said consul shall decide it, and no one else without anyone meddling in it. To consume the treaties of this period, not referring expressly to criminal jurisdiction as including both civil and criminal jurisdiction, is clearly proper in this case. There was no clear distinction at the time in Morocco between civil and criminal jurisdiction. The modern concept was not yet established that responsibility for the prosecution and punishment of criminal offenses was the function of the state. Instead, the punishment of offenders was the responsibility of the victim or his family, and the proceeding in a criminal case, as in a civil case, was essentially a contest or dispute between private parties. All right. Le Beau de la Protection as Morocco. To grant jurisdiction to the foreign consul, therefore, in any differences, disputes, contestations, or affairs between his nationals, as the treaties variously provided, was to grant jurisdiction in all cases irrespective of their character, civil or criminal, as long as they involve only persons of the same nationality. Thus, the treaties concluded by Morocco during the 17th century with France and the Netherlands, and during the 18th century with Great Britain, Spain, the Netherlands, Denmark, and France, granted jurisdiction to the foreign consul explicitly or by reasonable implication in both civil and criminal cases arising between his nationals. The United States Treaty was drafted in 1787. The text of 1836 was only a literal copy of the 1787 treaty. See Part 2, Chapter 1. Articles 20 and 21 provided, if any of the citizens of the United States or any persons under their protection shall have any disputes with each other, the consul shall decide between the parties, and whenever the consul shall require any aid or assistance from our government to enforce his decisions, it shall be immediately granted to him. If a citizen of the United States should kill or wound a Moor, or on the contrast, if a Moor should kill or wound a citizen of the United States, the law of the country shall take place, and equal justice shall be rendered. The consul assisting at the trial, and if any delinquent shall make his escape, the consul shall not be answerable for him in any manner whatever.
Could I interject real quick, please? I just had a question about that.
Yes, go ahead.
Okay. Okay, so I don't have the treaty in front of me, but what country, I mean, when they say country right there, like, are they saying if the issue, if in the political United States, or are they talking about the Empire of Morocco?
What treaty is he reading? Because I was writing and stuff. I'm writing.
Oh yeah, that's the treaty of peace and friendship they're talking about. That's Articles 20 and 21.
Right, go ahead. What's the
Yeah,
question?
So my question is, it says if a citizen of the United States shall kill or wound a Moor,
Mhm.
or in the contrast, or on the contrast, if a Moor should kill or wound a citizen of the United States, the law of the country shall take place.
All right. Let me explain. Because of conquest. All right. All right. You're asking that question because of conquest, because of Intercaterra Divina, European conquest. All right. So when somebody reads this who doesn't know about the true history and European conquest, they would think that this country is the United States. The country that we're in is United States. All right. So this is you know that the name of this country is not United States.
Correct.
United States is a political. We're talking about jurisdiction here.
Correct.
Jurisdiction. So the issue is jurisdiction.
So they are
Because
talking about Morocco.
what's that?
I said, so they are talking about the Empire of Morocco in that sentence right
Yeah, because all right, let me explain why. If you go to the title of the treaty between the treaty of peace and friendship between His Imperial Majesty, Emperor Morocco, and United States. Empire, not a kingdom, empire. A king did not sign that treaty. An emperor did. Moorish emperor, not a king, not a Moorish king. Now I'm letting you know, I'm not just saying yes, I'm giving you references so that you know, and everybody who's listening, everybody will be watching this, know that they're talking about the empire, and the Moroccan empire, not a kingdom. All right. Is that clear?
Right.
Oh, no.
Right.
I mean,
Yeah. The only reason I ask because I understand this is a bilateral treaty. So
no, are you clear? No. Not why you ask. I'm not asking why you ask. I'm asking you clear on what I said. No, you're not.
Yes.
You're not. So no. So answer is no. And once you go that means no. That means no. So go ahead. So what are you not clear about? But if you were clear, you would said yes. Not
Sure. So okay. So let me ask this. This is a bilateral treaty, correct? Bilateral treaty.
The treaty between the treaty of peace and friendship between His Imperial Majesty Emperor Morocco and the United States. That's a bilateral treaty. I mean, bi means two. All right. Morocco, between Morocco, Empire Morocco, and United States. So yes, that's two. Yes.
Gotcha. All right. So I can't really see the entire section. I scrolled down a little bit. I'm trying to open it up on my laptop. What I was trying to understand is under that article, are they referring to, like when they make that statement, if a citizen of the United States should kill or wound a Moor, and then in contrast they say if a Moor, because I understand the political zone United States is not a country. So are they saying that the consul basically, I'm just trying to see the beginning of it. Let me just open up the treaty if you give me a second.
Well, we don't want to have too much delay, brother, because we don't want to have too much airspace. So we can't give you a second. So no. We can't give you a second. We can't give you a second. So no to that.
All right. So all I'm asking is, there's equal protection for both the Moor and also the United States subject here in this clause, and the law of the country, which would be Morocco, is the superseding jurisdiction in this treaty. That's all I wanted to just.
The law of Morocco is the law that applies to the Moors. The law of Morocco is the one that applies to the Moors, not the United States Constitution. The United States Constitution doesn't apply to the Moors.
Right. That's not a country, though. That's not a country. It says the law of the country.
All right. Let me finish here, Mike. All right. Whether it was a country or not, because you're making more an issue whether it's a country or not. Because we're getting lost with that. We're getting lost with whether it's a country or not. Let's focus on jurisdiction. Let's talk about let me define extraterritoriality. You have extraterritoriality, consular jurisdiction. You have consular jurisdiction. Extraterritoriality, consular jurisdiction, which means that the laws of, you and I, Akeem, you and I are brothers. You have children, I have children. We negotiate a treaty. And in there, we have extraterritorial consular jurisdiction clauses in the treaty, which means while my children are at your house, the laws of my house govern your children in your house. While your children are in my house, the laws of your house govern your children while they're in my house. That is called compensatory, the older word that was used, the word that was used in the 13, 14, 1500s was called compensatory. Extraterritorial is modern. So extraterritorial consular jurisdiction. Now, when you talk about extraterritorial, and further explaining that, an extraterritorial consular jurisdiction, that means the Moorish consul, or i.e. the United States consul, would have both criminal and civil, deal with criminal and civil matters. But if it's just consular jurisdiction, it's just civil. You have extraterritorial consular jurisdiction, you have you have consular jurisdiction.
Yeah,
So I want to.
I got you, brother Bill. I get all that.
No,
I was able to find the treaty.
Akeem, this is not just for you. I don't just speak for you. I'm not just speaking for you. Please, it's not. Please, y'all, please hear me. When y'all ask a question, I'm never.
That wasn't my question though. Like you're kind of going off.
No, I'm not going off. I'm not going off, brother, because the focus you were talking about, whether it's a country or not a country, and you were losing it by saying it was more on whether it's a country or not a country. And the issue is extraterritorial jurisdiction, not whether it's a country or not a country. It was more emphasis on that. So therefore, the concept is lost. I mean, Sirius was reading for 15 minutes. So it's like the concept is getting away because the emphasis was placed more on whether it's a country or not a country and away from extraterritorial consular jurisdiction. What Sirius is reading is a series of clauses, articles from various treaties that extraterritorial consular jurisdictional clauses and various treaties. So when you were focusing on whether it's a country or not a country, like you put a lot of emphasis on that, the concept that Sirius was reading got lost. So what I'm doing is putting the focus, the concept, extraterritorial consular jurisdiction. That is the main focus. The principles get lost. It was getting lost into whether it's a country or not a country. That was getting lost. The principle is extraterritorial consular jurisdiction, which means that the laws of Morocco applies to the Moors, not the laws of the United States. When Moors are in United States jurisdiction, not land. Foreign doesn't mean land. Foreign relates to jurisdiction. So when you're Mike is at his job tomorrow. Mike goes to his job. The job was United States. It was coded under United States laws, the state laws of unions that's in the state of the United States. That comes United States jurisdiction, not land, jurisdiction. If there's an issue, the laws of Morocco would apply to Mike, not United States laws or state laws. That is extraterritorial consular jurisdiction. That's what Sirius was reading. He's reading a series of articles from various treaties. This is important because I don't want the point they get lost because a lot of people will be listening to this. Because then what happens is it's going to be, whether this is a country or not a country. And then so the main concept of extraterritoriality jurisdiction is lost. All right, let me move on. Sister Nana, you got a question?
Okay, so with respect to what Brother Akeem is saying, so Akeem, if you look at the boundaries of what we call the United States, right? First of all, we have to know that the time frame that we're talking about, right? Late 1700s. That's the United States of America in Congress assembled, right? So that's the lawful United States of America, which is also called the United States, which is also called the United States of America in Congress assembled, United States of North America. Those are the several states, the 13 states. We're not talking about the geographical area that we have come to know it as today, that political geographical area, basically say from Jersey Shore to California Shore, right? we're only talking about a small area because during that time, France, Spain, Great Britain, also the political jurisdictions, right? Abdullah, the political jurisdictions called Great Britain, France, and Spain also were here, as I had asked earlier in the conversation, and Abdullah eloquently explained to me slash us, to the listening audience now and in the future, how the jurisdictions were expanded. Remember that the United States of America was the baby company, or still is the baby company that spawned out of who? What? I should say what?
Out of Great Britain, the treaty between Great Britain and the United States, 1783 treaty. We got to go.
So there was this, just look at it as this is just, to help him out, and
I know,
to
but I'm
help
saying
out.
it's still getting lost though. We're still getting away
But
from. It's
we're
still
not.
getting
It's
away.
not. It's all tied in
No,
together.
it's not tied in, sister. It's not. I disagree with that.
Yes.
It's not, because
You can
this is just a
disagree.
clause. It's not. Go ahead,
Right,
sister.
but you can disagree, and that's okay for you to disagree. It doesn't take away from the fact that I'm still going to say what I'm going to say, even if you disagree, because I may disagree with what you or somebody else may say, but I still let that more speak. So just remember, brother, that the
Go ahead, sister. Go ahead,
great-
speak, sister. Go ahead, sister. Go ahead. Make your point. Make your point. Go ahead. I'm listening.
Akeem, are you there?
That rude stuff.
Hey,
Still.
Sister Nana, yes, I'm listening.
Yes.
Okay, so Great Britain had, like others, had certain territories here. The workers were disgruntled, right? The brutish wars. Now, that wasn't over where they call England or Great Britain now. That was here on this soil, and those folks were disgruntled when they came to the Moors that asked for assistance. Those employees asked for assistance. Those disgruntled employees asked for assistance with the brutish Moors. We're like, nah, you got to do that fight on your own. This is just real quick. Led to the.
You got 1 minute, sister. You got 1 minute.
The whole. Akeem, do me a favor and text me your number, and then I'll go over it with you. Okay.
Okay, Sister Nana, thank you.
All right.
Just do that, because what I do still want you to do is think that when we say United States, like today, when we say United States, we are thinking about this whole area, geographical area. When
30 seconds.
There are different definitions for United States. Back then, we were talking about the 13 several states that came out of the colonies.
15 seconds.
So just keep that in mind. So when I speak with you, just text me your
5
your
seconds.
number. Okay, just text me your
Yes,
number.
I just did. I just direct message you, Sister Nana.
Okay, all right. There you go.
Thank you.
You're
All
welcome.
right. Why serious? Continue reading, please.
Okay.
One
Need
second.
to see
Bring it back
full
up.
screen.
Bring it back up.
Okay. In the Treaty of 1682 with France, Article 16 provided, any Frenchman who shall hit a Moroccan shall not be punished until said consul has been called to defend the cause of the Frenchman. Similarly, the Treaty of 1770s between 1767 with France provided in Article 13, if a Frenchman hits a Moor, he shall be judged only in the presence of his consul who shall defend his cause. Article 14 of the Treaty of 1767 with Denmark provided, if there shall arise a difference between a Moor and a Danish national, the emperor or the governor of the place where this happens shall decide it in the presence of the consul, who shall deny his cause as he may. Dispute today may tend to connote argument and debate, civil cases, rather than physical exchange of blows, criminal cases. At the time the treaty was drafted, however, dispute connoted in English physical contest and combat, as well as argument and debate. Indeed, it was used for the purpose of referring to criminal cases in Article 9 of the treaty concluded in 1721 by Morocco with Great Britain. If any quarrel or dispute shall happen between any Englishman and a Mussulman, by which hurt to either may ensue, the same to be heard before and determined by the emperor only. And if an Englishman who may be the aggressor shall make his escape, no other Englishman shall suffer upon his account. It was used for the same purpose in Article 9 of the British Treaty of 1760. If there shall happen any quarrel or dispute between any Englishman and any Mussulman, by which any of them may receive detriment, the same shall be heard and determined by the emperor alone. And if any Englishman shall be the aggressor, shall make his escape, in such case, no other Englishman shall suffer on his account or in his place. It is also agreed that if any lawsuit, dispute, or any difference arises between the subjects of his Britannic Majesty, they shall be accommodated by the consul of the nation. Quick question: what is a Mussulman?
That's a word that they interchange with Moors. You'll see if you look at various that you continue to read. This will be text to you or email to you. You'll see that even in Moorish treaties that I have in Moors and Masonry Part 1, and then also in these extraterritorial consular jurisdiction clauses of these various treaties, you'll see there where Muslim and Moor used interchangeably. All right, so we're going to end here. Text your email, name and email in the chat if you want me to send this to you. It'll be this is the United States excerpt of the United States counter memorial to France's memorial in the 1952 case in the International Court of Justice between France and the United States. United States lost that case. As a result of losing that case, the United States Congress had to repeal the legislative act. So as a result, Eisenhower, in enforcing this case, had to close down United States consular courts at Morocco as a result of the United States losing this 1952 case. So United States, this is the count of 600, this is the excerpt of this United States counter memorial. As I said before, those who weren't earlier, the case started with France filing a memorial. It's called a memorial in international law. The United States had 6 months to respond with a counter memorial. That counter memorial is 600 pages long. I combed through it and took out the extraterritorial consular jurisdiction clauses of various treaties. There's also about 15 books that chronicles extraterritoriality or compensatory jurisdiction. That is the focus of my serious reading this. So I didn't want it to get lost. If it's a country or not a country, So text your name and email if you want to receive this excerpt of this United States Counter Memorial.
We already have most of the emails in.
I have most of the emails. Whoever wants it, we'll text it, we'll email it to you. I want to thank you. For those whose numbers I don't have, text your number and text me your number. My number is 215-300-5471. 215-300-5471. I have all right, TCL. Hey, I don't have your number. Rafael Bay, I don't have your number. Mad Love. All right, whether Nalani, I don't have your number, but you don't have to give me your number. But what I do is I send out the notices to people. All right. So we're gonna be ending in 1 minute.
Islam, I wanted to make a comment. Am I able to do that?
Sure.
Who's speaking?
This is Lamont Maurice L.
Oh, my man, brother. How you doing, brother? Yes.
All is well. We received
it's 10 o'clock, but go ahead, brother.
I got you. Just wanted to clear up some more concepts. The word country, I put it in the definition of the word country as it's read in the Black's Law 4th edition. And in relation to treaties, it's talking about one of the several states of the United States. So they mean the jurisdiction, the republic states. So the consular jurisdiction is exercised at the republic state. And remember, it's not a physical thing. It's not physical at all. So that's what we do. And the laws of the country would be the debts that the Moors contract with the citizens of the United States in accordance with Article 23 of the treaty between the United States of North America and the Moroccan Empire of 1836. Those laws, we actually have laws against the Charles County Corporation, which they abide by right now. Those are the default judgments that we issued against them. They are abiding by those laws. It's just that they are public. They're on the website, enforcetheconstitution.org, but we just haven't marketed and promoted it yet the way we were supposed to, because we're still getting things together. Just wanted to say that for the brothers' concepts, bro.
Absolutely.
Because that is important, because
extraterritoriality was getting lost. That concept.
And it has to be explained. Extraterritorial is consular jurisdiction. Right. So the extraterritorial jurisdiction, which is what the brother's talking about, that's the consular jurisdiction that's exercised in accordance with the common law of that country, which is the republic state law, not the color of law that they're talking about as far as driver's license, so on and so forth. That's color of law. That's not the common law. But there's a distinction.
What we're talking about, extraterritorial consular jurisdiction, Lamont.
I know. That's what I exercise.
Is meaning that the laws, like you and I have children. You and I are brothers. My children, while they're at your house, we negotiate that in the treaty that we negotiate, we have extraterritorial consular jurisdiction clauses. While my children are in your house, the laws of my house governs my children while they're in your house. While your children are in my house, the laws of your house governs your children while they're in my house. That is extraterritorial consular jurisdiction. And so I'm saying that was getting lost. The clauses that Viserys were reading were clauses with extraterritorial consular jurisdiction clauses from various treaties. I wanted the people to see that. I wanted to get them to see from various treaties dating back to the 1600s, where they look at extraterritorial consular jurisdiction clauses and treaties in 1600, 1700, and 1800. So they get a broad scope by analyzing various treaties. This is why I'm sharing this with people. And this is so you have a chance to read it on your own. Once again, put your email in the chat. So the laws of the United States Constitution does not apply to us. the laws of our country applies. That is extraterritorial consular jurisdiction. United States lost that when they lost that case, 1952 case. They lost the extraterritorial consular jurisdiction in that 1952 case. As a result, Eisenhower was forced, in enforcing that 1952 case in the International Court of Justice, Eisenhower had to shut down United States, not Moorish. Eisenhower can't shut no Moorish consular court. That's an act of war. That's an act of war.
Right.
For anyone to say Eisenhower shut down Moorish consular court, they do not understand international law.
They don't. Yeah, they don't.
Act of war. That's an act of war. He shut down United States consular courts and Morocco as a result of the United States losing the case in the 1952 case in the International Court of Justice. That's very important. All right. So
Wow.
I want to thank y'all for joining us. All right. Put your email in the chat if you want me to email this. Like I said, this is 600 pages. This is this excerpt of the 600-page United States Counter Memorial. All right. Thank you again. This class will be uploaded on the Moroccan Post Media YouTube page. All right. It'll be uploaded tonight. It'll be uploaded tonight in about an hour. So on the Moroccan Post Media YouTube page. All right. And I also send it out to you. So go to the Moroccan Post Media YouTube page and get the other classes. We have 12 classes, the Moorish Body Politic Formation class, as well as other videos. All right. So I want to thank everyone for joining us tonight. A lot of you came on late, so you didn't get a chance to hear Shem Malachi Bey. So get a chance to really look at the entire presentation. Shem really broke it down. He addressed a lot of misconceptions that's been out there for over 100 years. All right. So I want to thank everyone again. I definitely appreciate your time, and I honor everybody here. Thank you very much. Peace, everyone.
Islam, peace.
Thank you.
Peace, brother. Peace.
Peace to all the Moors.